Hello, everybody. Hello. Wow, I like that. Good morning, and thank you for joining us so nice and early here at Georgetown Law. We are so excited to have you here for a really important discussion, unilateralist presidencies and submissive legislatures, rebalancing our separation of powers. I'm Zanelle October, interim president of the American Constitution Society. ACS believes that the Constitution is of the people, by the people, and for the people. We interpret the Constitution based on its text and against the backdrop of history and lived experience. Through a diverse nationwide network of progressive lawyers, law students, judges, scholars, and many others, we work to uphold the Constitution in the 21st century by ensuring that law is a force for protecting our democracy and the public interest and for improving people's lives. Topics such as the ones we'll discuss here today are critical to the work that we do at ACS. And I have to say, really timely. Somehow our programs team always manages to plan these things so timely. But a special thanks to Deborah Perlin, who's done much of the organizing for today's event. 2020, as everyone knows, is a presidential election year, right? Candidates in both parties have seized the attention of American voters as we wonder who the next president of the United States will be and what policies he or she will pursue. And while now more than ever those are critically important questions, our unflinching focus on the presidential contest has the potential to mask a bigger question for American democracy. Has the presidency grown so powerful that it has thrown our constitutional balance out of whack? I'm sure many of you have those questions. Presidents decide when to engage in military conflict. They control our trading relationships and what international agreements we are party to. Presidents nominate Article 3 judges. The president promulgates regulations and controls law enforcement. And as recent events have taught us, there is no longer an effective check on the presidency by the other branches of government. So why is it that presidential power has grown and presidential accountability has shrunk so dramatically during our lifetimes? If, as many argue, the legislative power described in Article 1 of the Constitution is the most expansive, can Congress reassert itself, and what would that look like? These are the questions that will occupy us today. I'm so glad you all have joined us for this important and incredibly timely discussion. Thank you to Georgetown Law and Dean Traynor for hosting us. A big thank you to the ACS Georgetown Law Student Chapter, many of whom are over there, for coordinating and co-hosting today's event. And thank you to all of our speakers and for taking the time out to you from your busy schedules to be here. You're what make the ACS network thrive. And I can think of no better way to start today's conversation than by hearing from our first speaker, Congressman Jamie Raskin. Congressman Raskin is a longtime friend and member of ACS. He has served on the ACS Maryland Lawyer Chapter Board of Advisors and was a partner early in our nationwide Constitution in the Classroom program. Congressman Raskin proudly represents Maryland's 8th Congressional District in the U.S. House of Representatives, and I'm sure we have some of his constituents here with us today. Described as the best constitutional lawyer Congress has ever seen, Congressman Raskin, now in his second term, has emerged as a key player on the House Judiciary Committee, where he's a staunch advocate for executive branch accountability and reform. He's a former Maryland state senator, former constitutional law professor for more than 25 years at American University's Washington College of Law, where he earned national recognition for his ruminations on the Constitution's systems of checks and balances. Always eager to put theory into practice, Congressman Raskin has quite literally brought the Constitution with him to Congress, which we're so grateful for. He hopes to reassert the muscle memory of the American people on the questions of how our democracy is supposed to work. Please join me in welcoming a good friend of ACS and a true progressive champion, Congressman Jamie Raskin.
Okay. Well, Zanelle was talking about everybody's waiting to know who our next president is, but I'm more interested in who's going to be the next president of the American Constitution Society. But she wouldn't tell me. I didn't know whether Zanelle was herself a potential candidate. So you never know. But thank you for doing such a great job as interim president, Zanelle, and thank you all. She's doing a perfect job. Thank you for inviting me to be here today. I had to ask whether there was going to be press here, and they said just Garrett Epps. So that was that's a press I can trust. That's not a real enemy of the people there. That's a friend of the people. I'm psyched to be with all of you on this most essential question of our times. You know that I'm a staunch, true blue, progressive Democrat representing the people of Maryland's 8th Congressional District, some of whom are here. And hello, everybody. So I thought I would actually strike a bipartisan note or a nonpartisan note by invoking our last great Republican president, Abraham Lincoln, who spoke of government of the people, by the people, and for the people. And this indeed is the tantalizing dream of our country. But, we've just lived through this impeachment where we saw in the 2 impeachment counts high criminal behavior by the president, which was an attack first on popular self-government and the right of the people to have an election free of presidential manipulation and foreign government interference, and then presidential refusal to cooperate with the lawful demands of Congress for information. So I think that pretty much captures the basic malady of our time, that we have disrespect for popular elections and radically imperfect democracy because of the Electoral College, the gerrymandering of our districts, the interference of the Supreme Court, as we saw in Bush versus Gore, voter suppression, voter purges, and so assault on democracy. But then what is the related but analytically distinct issue of the imbalance now between presidential power and Congress. And so the main thing that I wanted to try to get across before advancing a couple of ideas for thinking about how we get through this, but the main thing I wanted to get through was how deeply the pro-executive assumptions of the time have sunk into even legislative and popular and academic consciousness. And so I suppose the thought I have is really just attacking one simple metaphor or term of art that's used constantly in this field, which I think goes right to the heart of our problems. And it happens every single time when the president violates another constitutional boundary or tramples rights, and I will see my Democratic colleagues on the floor leap to their feet, and they will say, Mr. President, you've got to stop doing X, Y, or Z. We are a, quote, co-equal branch of government, okay? And I think that this is the heart of our problem, that this is the 5th grade civics assumption that everybody has absorbed, and I suppose it works for 5th grade social studies, but it really should not work for us in terms of thinking about how our government is organized and how the constitutional design was created. First of all, co-equal is not a word, as far as I know, and there's something that's absurdly redundant about it. It's like saying, it's when people say it's very unique or extremely unique. I mean, either it's equal or it's not equal. It doesn't have to be co-equal. All right, so there's an assertion out there in popular consciousness, we are an equal branch of government. But I think that creates a lot more problems than it solves for us in terms of understanding the real constitutional design. Go back to the beginning, and we overthrew the king. We overthrew the monarch. And in the original Articles of Association, Articles of Confederation, there wasn't even a president, right? And when the Constitution is written, it begins with the first three majestic words, "We the people, in order to form more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and preserve to ourselves and our posterity the blessings of liberty, do hereby ordain and establish the Constitution of the United States of America." The entire action-packed preamble, all in one sentence, and then the very next sentence is Article 1, launching the experiment, saying all legislative power is vested in the Congress of the United States, the United States Senate, and the House of Representatives. Then you get 37 paragraphs spelling out all of the expansive powers of the Congress, the lawmaking branch. We've got the power to regulate commerce domestically and internationally. We've got the power to declare war. We've got the power to make appropriations and spend money. We've got the power to raise taxes. We've got the power to raise an army. We've got the power to maintain a navy. We've got the power to exercise exclusive legislation over the seat of government in Article 1, Section 8, Clause 17. We've got the power in Article 1, Section 8, Clause 18 to exercise all other powers necessary and proper to the foregoing, to the execution of the foregoing power. So all of that is laid out. Then you get to Article 2, 4 short sections, and the fourth section is all about impeachment, how you impeach a runaway president, right? And then outside of that, what's the president's main job? Well, to be the commander-in-chief, not of the country, as people will say, not even of the armed forces, but the commander-in-chief of the Army and the Navy and the militias when called into service in times of actual insurrection, okay? What is the core of the job? To take care that the laws are faithfully executed. The president is created to implement and to execute the laws that the people have adopted. All right. To me, it's important that Congress has the power, mentioned multiple times in the Constitution, to impeach the president and other civil officers. And the president does not have the power to impeach us, which I think underscores Madison's point in the Federalist Papers that we are, of necessity, the predominant branch of government, the primary branch of government. So I don't buy any of this co-equal stuff. That supports confusion about how we're supposed to be operating. Congress is primary, Congress is predominant, and the president's job is to execute. Now notice that formulation of it elides the whole question of the unitary executive. You could be pro-unitary executive jurisprudence or anti. Regardless, Congress is still the boss in terms of defining the laws of the country. And we have to wrestle separately with the problem of the unitary executive. I think it helps to inform our sensibility about it, but I think you could come down one way or another on that whole question, but still understand what the proper contours are surrounding presidential power. So we live in a time, of course, where executive power has run away, and a lot of it is traceable to the rise of the national security state apparatus after World War II, the arrogation of war powers to the president, the development of presidential wars, unilateral presidential wars, undeclared unilateral presidential wars. And what we need to do, and I'm proud to be a little part of this and participating in Congress, but what we need to do is to reassert the proper powers of Congress. And we've been doing that on the war powers. We've done it with respect to Iran, stating that we have not declared war against Iran or in Iran, and that the president may not proceed with military hostilities against Iran without a declaration of war or authorization by Congress unless there is an attack on our country or upon the armed forces, which is how the War Powers Resolution works. But because we live in a time of such untrammeled and arrogant executive power, what we need to do is to develop a series of statutory frameworks surrounding each of the powers that's being usurped from us. So what exists in the War Powers Act, and I honor what Congress did back in 1973 after the Vietnam War, but what we did there, we've got to do with respect to appropriations and spending. I mean, how is it possible that Congress decides, no, we are not going to appropriate money to build the medieval border wall in Texas, and yet the president then goes ahead, directly contravening the congressional decision, and starts plucking billions of dollars from other appropriated purposes for other programmatic purposes? We've got to figure out a way to move quickly, to have a statutory mechanism in place to move quickly to deal with that. The Foreign Emoluments Clause is another example, because the Emoluments Clause says in Article 1, Section 9, Clause 8, that the president, in fact, none of us in high office, none of us can receive from a king, a prince, or a foreign state a present, an emolument, which means a payment, an office or title of any kind, whatever, without the consent of Congress. And every other president prior to Trump has adhered to that constitutional admonition scrupulously. Abraham Lincoln got some wonderful elephant tusks from the king of Siam in the middle of the Civil War, and he even then went to Congress to ask whether or not he could keep them. And Congress said, no, you can't. They should be turned over to the Department of Interior. And Andrew Jackson, who, is Trump's big, racist white nationalist hero, he went to Congress to ask for permission to keep a present that he received. So we got a whole list of them, and then you get to Trump, who said he's going to, maintain more than 500 businesses all over the world, and he'll be the judge of it. He's been making these ridiculous payments. He made a payment of like $340,000 to the U.S. Treasury, saying this represented the profits from money that the hotels have gotten from foreign governments, which gives the whole game away. Because for one thing, the Constitution doesn't say the president can't keep the profits from payments he receives from foreign governments. It says he can't receive any payments from foreign governments. And he can't receive anything without coming to Congress first. And he's just bypassed the procedural threshold, which is congressional consent. So what we need is a mechanism akin to the War Powers Act, the Emoluments Enforcement Act, which will enable Congress, when we are alerted to the fact that the president is pocketing money from Saudi Arabia, United Arab Emirates, Turkey, Philippines, whatever it is, that we are able to put the president on alert quickly, saying we believe that you are in possession of foreign government payments. We're giving you 5 days or 7 days either to come and explain why that's not true, why it's a mistake, or to seek our permission. And if not, then we will have an automatic, or we'll move quickly to the floor to vote on rejection and disapproval of the emoluments. And that's something that we don't need to get through the House and the Senate, because I think, anyway, that it's sufficient if one House says no, because the Constitution says he needs the consent of Congress. So if the House of Representatives says you do not have our consent to keep the millions of dollars from the Chinese government, for example, that he's collecting in rent at Trump office tower in New York, then it would be effective at that point. And then the only question then is, well, what are the sanctions that we would apply that would go in either automatically or we would decide in each case? So I'm hoping that we're going to have hearings on this, but that's just exemplary of the kind of thing that we need. If you have a president who's in place who simply disregards the Constitution with respect to war powers or appropriations or the Foreign Emoluments Clause or you name it, then you need to put mechanisms in place that will move quickly to have Congress to act so we don't normalize this kind of misconduct and contempt for the Constitution. So that would be my suggestion to you in terms of things to talk about, how to build springing legislative oversight into each of the areas where the president has been usurping our proper powers. So that's my thought. I wish I could stay and hang out and have this conversation, but that's not my life anymore. But I look forward to seeing whatever is going to come out of the discussion today. And thanks for letting me drop by. And I have time for a couple questions, I believe. Let me see. Yeah, I've got 5 minutes. So yes.
What about the Impoundment Act? That was intended to be one of those legislative safeguards, and it didn't seem to stop Trump at all.
Yeah, I mean, well, the Impoundment Act from '73 is a great example. That was another attempt, post-Vietnam and Watergate to try to build some of those guardrails into place. So I think that's something that we got to look at. Why did the Impoundment Control Act not work? Now, it was raised by the people who ended up, I think, resigning from OMB. They raised it, but yeah, I mean, it's sort of just been kind of drive-by collateral damage in the process. So we've got to look at rehabilitating it and building more force into it. Yeah.
You mentioned appropriations, war powers, emoluments. Another area that's of great concern is the bypassing of advice and consent and basically the circumventing of the Vacancies Act. I wonder if you could talk a little bit about that and the role that you see that plays in this.
Yes. Well, this administration, of course, has been operating with acting cabinet officials and acting people throughout the government. That is also another unforeseen or unforecast mechanism of bypassing the Senate's advice and consent power. It's also, interestingly, a way to bypass congressional power under the 25th Amendment. And some people think that's not coincidental, that the president has been very nervous about a majority forming of his cabinet officials to declare that he has incapacity to govern under the 25th Amendment. The 25th Amendment is another place to talk about what Congress can be doing, because Section 4 of the 25th Amendment says that either the vice president and a majority of the cabinet can act in the event that the president lacks the capacity to successfully execute the powers and duties of office, or the vice president and a majority of a body set up by Congress. And what's interesting is Congress never set up the body that could act like the cabinet. I mean, that's sort of a mini separation of powers principle built into the 25th Amendment. Either the cabinet could act, or the framers of the 25th Amendment, Birch Bayh and Robert Kennedy and so on, understood that, well, the cabinet might be held under the sway of the president or could be filled with acting people, maybe partly for this reason. So there could be another body set up, but we've never done it. And I did, in the last Congress, introduce legislation to establish the body. It was sort of a play on words. I think we called it not the President's Council on Fitness, but the Council on the President's Fitness. But when we had, I think, 75 or 80 co-sponsors, but no Republicans did it, so we weren't able to get it through. And then when everything started on impeachment in this Congress, we decided to set the 25th Amendment aside, although I was a dissenting voice in that decision, because I think, just because you're committing high crimes and misdemeanors doesn't mean that you're not deranged too, right? You could be both guilty of high crimes and misdemeanors and also incapacitated, and vice versa. I mean, I suppose there's a Venn diagram of people who are criminal and people who are unfit for other reasons. Yes?
So I like to think of acting as having a double meaning. It's someone's temporarily in place, but it's someone who is pretending to be someone else, right?
Absolutely, yeah. So I don't know that we've developed any means for dealing with that. That's something that, and I've not really thought about that, but that would be a great thing to deliberate at this conference. What do you do? I mean, what happens if the entire cabinet is acting? Just take the cartoon example. What do you do with that? Vacancies is a similar problem. I mean, we have an unprecedented number of vacancies, huge number of vacancies in the IG positions too. That's something that we could try to rectify legislatively somehow. So, all right. Well, again, very eager to see what you come up with. And I understand it's not necessarily a symposium issue or whatever, but it would be great to at least develop some written summary of what it is you guys find and what you think about. All right, thanks for having me.
Good morning, everyone. My name is Grace Edwards, and I am a first-year section representative at the Georgetown ACS Student Chapter. Thank you. First, I'd like to thank Congressman Raskin for being with us today and for his inspirational remarks. What a great way to start today's symposium. It is my honor to introduce Kim Atkins, who will moderate today's first panel, The Rise of the Unilateralist Presidency. Kim covers politics for WBUR, Boston's NPR news station, and serves as a guest host for the nationally syndicated NPR program On Point. She also provides on-air analysis and commentary on national political news as an MSNBC contributor. Prior to joining WBUR, Kim served as the Washington bureau chief at the Boston Herald and for the Dole & Company newspapers. A graduate of Boston University Law School, Kim brings her legal education to her journalism, an asset that enhances her legal and political analysis. Kim is a regular in ACS circles, and we are so glad she can be with us today. Please join me in welcoming a close friend of ACS, Kim Atkins.
Thank you all, and thank you so much for coming. Can you hear me? Okay, great. So we have a robust discussion on this topic, and I want to get right to it. First, I want to very briefly introduce our very esteemed panel. It would take the whole time to give all of their bonafides, but their full bios are in your material, so I will hit the highlights. First joining us is the Honorable Brad Miller. He is a counsel at Gutman Bushner Brooks PLLC, where he returned to. You want me to pick up the mic? Okay, I can do that. Where he returned to private practice in 2013 after a decade of serving in the House of Representatives. And he is joining us today, and I appreciate his appearance. Sorry, I just got done running, so I'm a little out of breath. We're also joined by Erica Newland, who is of counsel. Who is counsel at Protect Democracy, and she formerly served as an attorney advisor at the Office of Legal Counsel in the Department of Justice. Also, Victoria Norse, who is the Ralph V. Whitworth Professor in Law at Georgetown University Law Center, and is published widely on the topic of the power of the president and separation of powers. And finally, we have Sai Krishna Prakash, who is the James Monroe Distinguished Professor of Law at the University of Virginia Law School, where his scholarship focuses on the separation of powers and particularly executive powers. So we want to talk about the unitary executive and the power of the executive today. It's a fitting time, the day after a historic vote on impeachment on the issue of whether the president overstepped his powers. And I want to start our discussion by taking a step back, looking at the historical nature the executive versus the legislative power, the legislative check on the executive, and the original understanding of it. I will start with you first, Congressman. What is where do we get this foundational understanding of it, and what should have been on the minds of the senators yesterday, for example, when they were casting their votes?
Well, unfortunately, it was very clear very early that it would be a partisan vote. And it certainly wouldn't turn on any kind of nuanced understanding of the Constitution and the allocation of powers in the Constitution. I don't think members of Congress or politicians generally are constitutional scholars or political philosophers. They don't have to be. I mean, it was kind of cool that Edmund Burke was a member of Parliament. It was helpful that Representative James Madison was in the original Congress. But members of Congress don't really need to be constitutional scholars. I mean, they don't have to think about things on this level. Even the Federalist Papers and their description of the purposes of separation of powers really describes turf protection as the check by one branch on the other. If one branch kind of intrudes into the other's turf, that the branch whose turf is intruded upon will do something about it. But it's very, very difficult to look back to the Constitutional Convention. I know there's a question of why should we really be bound by what they thought in 1787. To look back at the Constitutional Convention and say, yeah, they really intended to create a very powerful executive. Hamilton did. But the rest really did not. They believed, as I believe, that democracy really lives in the legislative branch. And they were fearful of an executive. There wasn't an executive under the Articles of Confederacy. And there, I know that conservatives, the rightist legal scholars who believe in the unitary executive, think that Morrison versus Olson, which upheld the independent counsel law back in the Reagan administration, was like, as bad a decision as Dred Scott, and revere the Scalia's dissent. But Rehnquist's 3-sentence footnote dealing with his arguments is correct, I think. The text of the Constitution doesn't support this. The Constitution gave broad powers to Congress to structure government, and the position that Scalia is taking is so uncompromising that it would make democratic government impossible. There was just, I don't want to monopolize the time, there were, the term unitary executive is snatched from one of the Federalist Papers, in which that was explained what they decided instead of what was Franklin's idea of a committee that would run the country, that would serve as the executive. They didn't intend this all-powerful figure. They didn't even really intend that the president be elected. They expected he would be, that the Electoral College would be a deliberative body and that they would pick who he was, which was Hamilton's preference, because he didn't like elections. He thought that the House, because it was directly elected, would be a lot of lowbrows, mouth breathers. He may have been right, but and that the Senate, because it was picked by legislatures, would be much more to be respected, and that the president would be, because he was not directly elected. They didn't think a direct election was possible. But Barr's 20-page memorandum to Rod Rosenstein and the head of OLC on Mueller's investigation said that framers intended this one decision by the whole people to elect the president. They didn't think there'd be an election at all. The power of chief executive, commander-in-chief, there was a lot of resistance to giving the president that power. First of all, they didn't want a standing army at all. A lot of delegates didn't want a standing army at all. They became persuaded that they really needed to have a standing army. But that's the only limitation on appropriations, 2-year appropriations for the Army. There's ample support in the Constitution itself, in the Federalist Papers, in the journals of the convention, that they really did expect a balance with the center of gravity of American democracy being in the legislative branch.
And I want to get back to this discussion of the unitary executive theory and go to Erica next. But first, I forgot to say at the top, we will have some time for audience questions at the end. So if you have them, just hold on to them, and we'll have you come ask them once our discussion is done. And of course, I want our experts to feel free to jump into the discussion. It's much better when you're talking to each other because you are the experts. But I do want to throw it to you, Eric, on this idea of the unitary executive theory. As a congressman mentioned, that the DOJ has played a role in that, and sort of talk a little bit about how that role has evolved.
Yeah, so let's see if I can grab the microphone. Is that better? My understanding of the history here is that the unitary executive really was codified by DOJ, this theory, during the Reagan administration in 1980. You see a lot of foundational precedent being created at the Office of Legal Counsel where I had worked. And there's an example I like to give that I think really instantiates or demonstrates well kind of how powerful this view of the Constitution is. And it's around the recommendation clause in the Constitution. I don't even remember where that is in the Constitution. You can look through your little booklets there. You've probably never heard of it. But it says that the president shall recommend certain legislative measures to Congress. And the way OLC and the Department of Justice has interpreted this clause is not only does it mean that the president has to recommend legislation, it means that if Congress ever in legislation asks an agency to recommend legislation, especially an independent agency, that all has to get channeled through the president first, and Congress can't even require a recommendation. The president has to decide on his or her own accord to recommend it themselves. And I think that I like to think about that example because it shows how a power that was not necessarily granted exclusively to the president has been seen and interpreted as a kind of core piece of presidential power, I guess. And in a way that takes from Congress and that sees this zero-sum game with Congress rather than additive or supplemental interactions. You know, at OLC, folks like to talk about the idea of ambition counteracting ambition. And one of the kind of philosophical justifications, so this is from Madison, from the Federalist Papers, one of the kind of philosophical justifications for that, for the unitary executive theory, there are a lot, and we could talk about that for hours and hours, I think. But is the idea of loyalty up to the president, who then is representing the executive branch in a fight with Congress to the death. And I think it's worth asking whether those presumptions hold that that's a good way to govern when Congress has failed to offer any ambition that is counteracting. So I've kind of gone from unitary executive to checks and balances, but there we go.
But all these things go together. That's a good way to lead this discussion. And also a part of that is the idea of originalism versus textualism. What does this say? Is this something that was meant to evolve? Si, what do you think about that?
First of all, it's a great pleasure to be here today and to see all these folks getting up so early on the National Prayer Breakfast Day. I understand there's a big traffic jam going on. So I actually believe in the unitary executive in the following sense. I believe that Congress makes laws, the courts adjudicate disputes, and the president's supposed to execute the laws. That means to be an executive, and I understand unitary executive theory to be about. Speak more. I understand the unitary executive theory. Thank you. I sound louder now. I sound more authoritative. I sound more authoritative. I understand the unitary executive theory that the president gets to superintend the execution of the laws, that the Constitution itself, by granting the executive power to the president, gives the president the authority to execute the laws and to see them executed. The Take Care Clause imposes a duty. And I think there's ample evidence of that at the founding. President Washington supervised all execution of federal laws. He told prosecutors whom to prosecute, whom not to prosecute. This goes to Congressman Miller's claim about the independent counsel. And so I think as a matter of constitutional law, the President of Washington took many measures that aren't traceable to any statute. No statute authorized him to remove any officer. No statute authorized him to direct the actions of prosecutors and tax collectors. He did that by the Constitution itself. And then there's a question of, well, if he has this constitutional power, does Congress have some authority to take it away or modify it? And there's the necessary and proper clause, there are other clauses, but I would not read the Constitution as authorizing the Congress to strip away parts and parcels of the executive power, just as I would not read them as having authority to, strip away the powers of electors who participate in the Electoral College. So there's the question of the unitary executive and what role it's played in presidential power. I think, as Congressman Miller suggests, there are lots of clauses that one could cite for the accretion of presidential power, and one could try to blame people like myself for the predicament we're in. I think, I'd like to say there's more than enough blame to go around. I'd like people here to introspect about what it means to say that we have a living Constitution. Because I think if you think that, the person, the entity that has the greatest influence on the future shape of constitutional law is the president. The president appoints people to the courts, which has an effect on the future shape of constitutional law. The president makes constitutional law through transgressive violations of the Constitution, see war powers. And the president, basically grabs other powers via his or her actions. And so if you believe in a living Constitution, you have to understand that you are basically empowering the presidency as an institution to transform constitutional law. And it may well be that, until recently, most of these transformations were for the better, at least from certain perspectives. Whatever the case may be, my point only is that the presidency wields the greatest influence on the shape of constitutional law via his or her appointments and via his or her actions. I think I've said enough for now, so I'll stop.
Victoria, I want to get your thoughts.
Can you hear me? Okay. So I am not a unitary executivist. I don't believe that the unitary executive is consistent with the text of the Constitution. I don't believe that that was the design. I am more along Representative Miller's side on that, and I'll explain why. My understanding of the separation of powers is that, just like all legislation, the Constitution itself was built in a process of amending various potential structures. So the presidency was not even created as an independent entity until the very end of the Constitutional Convention. The vesting clauses, which say the president shall have executive power, all legislative powers are in, these are the first parts of each article, Article 1, Article 2, Article 3, were added by the Committee on Detail or Style at the end. These were not the major things on which people voted. They voted on the particular powers. So when I read the text, I read a text to harmonize the powers and to look at all of them as opposed to gerrymander them. And what I mean by gerrymandering is precisely Justice Scalia's dissent in Morrison versus Olson. I actually agree that he was right about the independent counsel statute. I think it gave too much power to Congress and it incentivized impeachment, and then that's dangerous. So I agree with his result, but his reasoning, I believe, is quite dangerous. And his reasoning was something like this. The Constitution does not give some, emphasis on some, italics, of the executive power to the president. It gives all of the executive power. Well, guess what? All does not exist in the Constitution. He has added that. And that's the theory that I think is dangerous. Other people have different versions of the unitary executive. Professor Prakash and I could bore you with all sorts of details. Some people think it's just about the internal design of the executive department. But there is one version of it that is taken from this dissent, as if this is prophetic, like one of Holmes's dissent in the First Amendment cases. And if you actually read Justice Scalia's language, it's dangerous. Why? I've worked in the White House. If you give presidents all power, they'll do what they want, right? And that includes President Obama. All right? President Obama wanted to do DACA DAPA. He knew, he's taught constitutional law, he knew that he didn't have a statute to which to hang his hat on, or at least he wasn't looking for one hard enough. And eventually he did it. Why? Because it was important to him politically. Every president pushes the envelope. Jefferson did it. Lincoln, the Emancipation Proclamation was a war power. Every president pushes the envelope. And if you want to encourage them to just keep pushing, then say they have all power. Well, that word is not in the Constitution. And I think it's a dangerous permission. Why? Because I treat the baseline of the separation of powers as legislation, which requires the joinder of the Congress and the president and allows the legislature the ultimate decision for a 2/3 override. That's what Justice Jackson said when he came back from Nuremberg in steel seizure. Now, lots of people say, oh, that's living constitutionalism, blah, blah, blah. I hate that term. Bad slogan. Really, really bad slogan, because it suggests that people just make up the Constitution. It's also a slogan about what the court does. And the court is part of a bigger structure. Okay? I believe that the baseline should be agreement between the Congress and the president should, like good presidents, go up to. I saw George H.W. Bush. I was working on the last time I saw all the senators there, as I've been locked in PBS's studio doing play-by-play of the impeachment, so I'm a little dazed. It's a black room, no windows. In any event, the last time I saw all the senators sitting there was when Kuwait was invaded, and they all sat there and they voted for a war to protect Kuwait. That's what George H.W. Bush did, and that was the right thing to do. I don't think if you encourage presidents, they all push the envelope because they have to, because the real separation does not depend upon a definition of power. No one knows what the definition of executive is. There are executive agencies over at Congress. They have the Capitol Police. That executes. They all do all the functions. Function was not a term of art at the time of the founding. They thought of the real power that was separated was personnel. This is Steve Calabresi's view. We don't have a parliamentary democracy. Nancy Pelosi can't be Secretary of State at the same time. We don't have a joinder of parties between the executive and the legislative. What we do have is they have different constituencies. The president speaks to the nation. He can get away with doing what he does based on what the people are the ultimate determination, not the Supreme Court, because the Supreme Court intervenes in a minimal number of cases. They should be intervening in more right now because they're not deciding, at least they're going to decide the Mazar case because they're being really slow about all these subpoenas. But that's the ultimate separation of powers. That's why the form of our government, if you look at it as a building, has this huge lean-to in the executive because the people have demanded that there be greater execution and more professional government. All right, sorry.
And I want to ask this. I mean, now that we have this historical and constitutional foundation to this discussion, are there alternatives? I mean, is there something other than a unitary executive that would work constitutionally?
Well, I think I think there are a lot of people who are, nervous about what the presidency has become. I'm certainly one of them. I think everybody in this room believes there's only one president, and they also believe that that president has certain authorities that other people don't have. And I think what's gone on is this phrase "unitary executive" has become a boogeyman for lots of different problems. But the president's power as commander-in-chief does not derive from the theory of the unitary executive. Unitary executive, and I've written about it, is just a claim about law execution. And Scalia's theory in his dissent isn't about the commander-in-chief power either. So I guess this is nomenclature, and this is an odd, maybe an odd and unimportant thing to say, but I would not be focused on whether we have a unitary president. We certainly do. Now, maybe when, Cheney and Bush were in office, people might differ, but, no one thinks now that, that Mike Pence is making the decisions. Maybe President Trump isn't either on certain decisions, but I think the question is what has the presidency, this is my perspective, and I know others will disagree, but what has the presidency become, and is there a better model for it? And I would say, yeah, it's the original Constitution. Under the original Constitution, the president could not wage war at his will. That was something that was added over time. The biggest disruption in the war Constitution was Truman's invasion of Korea, or defense of South Korea. And then ever since then, we've had presidents take us to war, including President Obama and maybe this president with respect to the Syrian airstrikes and the killing of Soleimani. There's just a number of ways in which presidents have accumulated power. And, again, you can call it the unitary executive if you want to, but I don't really think that describes what's going on. Everybody believes there's only one president. So I don't know why that would be the way we would discuss it.
So I largely agree with Professor Prakash, but I would add another dimension to the conversation about the unitary executive. And this comes from having worked on constitutional law as a bureaucrat within the Department of Justice, which is one way that the unitary executive can structure the execution of the law. Isn't a concept of two commanders in chief or anything like that. It's about what duties the people who are interpreting the law and are actually on the ground or one level up from the ground, implementing and enforcing the law, feel like they have to the president, to the Constitution, and to the bar when there are attorneys who are doing this. So there is a live debate within OLC. You see this playing out in public opinions about whether and in folks who've come through OLC and then are writing on it, which is its own, as Professor Nurse and I were talking about, before, is its own like subgenre of academic scholarship. About whether that duty of loyalty runs directly to the president. Is the job when interpreting the Constitution for lawyers who are within the executive branch to interpret the Constitution as the president sees it and wants it? Or is it to interpret the Constitution somewhat independently, maybe within a range, and then recognize that the Attorney General or whoever the relevant cabinet member is and the president have a prerogative as our one president to overturn that interpretation? Those can lead to very, very different outcomes. And the same is true when you are prosecuting crimes, when you are interpreting agency material. And I think that same debate gets played out when you are thinking about appropriate structures for the executive branch. How much independence can the CFPB have, or different independent agencies? How much should they feel like they are obliged by our constitutional structure to do the president's bidding? And how much should they feel like they are obliged by statutes, oaths, other sources of authority to comply with those law-giving structures, recognizing that the president does sit at the top of a lot. And I think that really matters for how our government does business.
And I want to hear from the other panel specifically on this issue of loyalty to the president and how you create a difference between the idea of loyalty to the presidency or loyal to a particular president. I mean, I was struck in the impeachment proceedings. I think one of the most astonishing moments was when the president's attorneys argued that he is the executive, that he himself, one person, was the executive. Does that coincide with your view, and why not?
Well, I just want to say that we've now gotten to where the rubber hits the road for some versions of the unitary executive. Some of them are very all-encompassing, but some of them are more limited, and I think this is what maybe Justice Kavanaugh would say, or Professor Prakash, which is that it's about a unified executive branch so that they want to get rid of independent agencies. That's where the rubber hits the road. Now, you can want to get rid of independent agencies because you want to just get rid of agencies because you don't like regulation. Or you can honestly believe that they are an excrescence and some kind of bizarre combination of congressional power and presidential power, and therefore outside the original constitutional vision, which I assume is something akin to many who focus on the unitary executive. I personally believe that the Necessary and Proper Clause gives Congress enormous power to structure the government, and they've used that for 200 years. And because it gives Congress actually the power of the entire government. Read it carefully. My colleague John McKyle has written the most eloquent and precise views of how far it goes. It just doesn't mean all of the herein granted powers that can above, but all the powers of the government. So I don't believe independent agencies are unconstitutional, but the court is hearing all these various cases like free enterprise, et cetera, and they're trying to make it so that the president can control this. Now, I will say also, having worked in the White House, that there's an old saying that when the president walks in, he thinks he can control the powers of America, and he or she is very, we haven't had any she's, very, excited, and you are hemmed in. It is both over and under regulated, trust me. You can't make a conference call without thinking you're violating the Paperwork Reduction Act, and a few other things, and the Presidential Record Acts. I had to steal people's phones. I mean, it's nuts. So we really do need to come up with a better system because Impoundment Act is a good example, right? OMB follows the Impoundment Act. I asked Howard Shalansky. He used to head, OIRA, which is, the body that governs the law of OMB. And he said they just included in their checklists. Good lawyers try to follow the law when they're in the White House. The law is what Congress and the president have signed together. The president signed that, right? So they're joinder. He gets to execute the laws, but the laws come from Congress, right? So he cannot, by definition, be executing something that is not connected to a statute. The reason I objected to DACA DAPA, and I said it was going to get struck down, much to the chagrin of my colleagues who were in the White House counsel's office, was that there was no statute that authorized the president to do it.
So over time, historically, there have been shifts between the executive power and the legislative power, and I want to move the discussion a little bit there to how those two intersect. Have there been certain inflection points where the legislative and the executive branch expanded and constricted? I know in leading up to this, Congressman, you talked about 2006 and how the Democrats took control of the House during the Bush administration, and they had to consider what the subpoena power was. Can you talk about that or other inflection points that all of you can think about?
Well, there certainly has been a change in the last 40 years. I don't recall this was an issue in American politics before the Reagan administration, and I think that there was a slowness to recognize the importance of the issues that were involved. If I may lower the intellectual tone for just a moment, I saw on late night cable, or I don't actually stay up late at night, but on cable, I saw recently the movie Bill and Ted's Excellent Adventure. I assume all of you saw that as participants in American culture. And Bill and Ted are these mindless teenagers, and they discover a time machine, and they decide they'll use it for a history report. But one scene is that they are transported into the future, hundreds of years into the future. And the response it's you, it's Bill and Ted, and they're revered figures in the future. And I kind of think that's how the framers of the Constitution, the delegates of the Constitutional Convention, would now view the way that original intent is regarded in what the Constitution means and how American government should function. They never expected that it was like, well, let's try this. We kind of spent a summer trying to work this out. Let's see how it works. And there is a passage in this widely quoted passage in one of the Federalist Papers by Madison saying this will be liquidated. It's another reminder that was a long time ago, because you would not see the word liquidated used in that way now. It's not quite as bad as trying to read Chaucer, but the language of the Federalist Papers does seem kind of quaint. And Jefferson said, similar things, that we're going to see how this works, and this will eventually, our government will work, not necessarily exactly how we've written it, but how Americans make it work, and that's okay. And for 2 centuries, although we idolize the framers, I don't think that they thought that they were doing something for the ages. I don't think they thought they were carving in granite. It has worked not because the design was so brilliant, not because it was divinely inspired, as some have said, but it's because Americans have made it work. They've wanted to have a democracy. And that hasn't always worked. There was some unpleasantness in the 1860s, you may recall. But generally, it has worked because Americans have made it work when Americans have made it want to work. Obviously, there's a big shift after the Civil War. the Civil War itself was a big shift. I mean, there was obviously a debate before that. Ken Burns said that before the Civil War, the United States was plural. After the Civil War, the United States was singular. It was United States are versus the United States is. I mean, there was a big change then and afterwards. And then the New Deal. The New Deal was a huge change. And the creation of executive agencies, because there's no way for Congress to turn loose of important decisions without some control of it. They created multi-member agencies, members with required partisan balance. Members could not be fired for policy differences. They could only be fired for cause. All of those decisions have come since the New Deal and are the practical necessity of trying to make democracy work, trying to make our Constitution work in what has become a very complicated, large economy in a complex country. And then the changes since the Reagan administration decided that the post-Watergate reforms went far too far. And in fact, they wanted to ratchet it further back than that, really to take it back before the New Deal. They really wanted the, what's it called, Humphrey's executor, the decision that upheld the structure of the Federal Trade Commission. They wanted that decision reversed by Morrison v. Olson, and they felt confident that it would be. And instead, Rehnquist's opinion, in which 7 justices joined, Kennedy did not participate. So it's 7 out of 8. Only Scalia dissented. Relied upon that opinion extensively in the decision. I do think as a policy matter, not just as a constitutional matter, I do agree the old special counsel law went too far. There was a hair trigger. It was abused. Members of Congress and other executives, incurred enormous, ruinous legal costs in defending against criminal charges that were really based upon very little, very flimsy information. And I can't remember who it was that said it, but after a special prosecutor decided not to pursue criminal charges against one, he said, now where do I go to get my reputation back? It was greatly abused. I mean, in the Clinton administration, it was abused. I mean, we all remember the Ken Starr investigation, which started out about a land deal in Arkansas. It was abused, but the judiciary, the Supreme Court, has asserted that contempt of Congress is such a critical power of the judiciary that if the president refuses to prosecute, if the executive refuses to prosecute, then the judiciary can appoint their own to prosecute, their own counsel to prosecute contempt of court. So there's a lot of support for the idea that there is not a perfect demarcation between these branches. And yes, I wrote a piece in American Prospect that ran last fall that kind of recounted my own fights with the Bush administration when I was an oversight subcommittee chair. There was an enormous shift, and a great deal of it was not public. OLC opinions are not published, and the Bush administration claimed and certainly exercised powers to act in secret that I think are incompatible with functioning democracy.
I want to go to Cy and also Erica on your thoughts on OLC as well. Go ahead, Cy.
I mean, I'd like to chime in about the New Deal and the delegation of legislative power to the executive branch and, for that matter, independent agencies. It's commonly said that Congress just can't legislate because we have such a complex society and it doesn't have the expertise or the time. And I'll defer to the congressman on whether Congress has the expertise or the time. But I will say that when you delegate authority to the executive to make rules, and when you delegate to the independent agency authority to make rules, you're basically giving the legislative power to the president, because the president every 4 years comes in and rewrites all the rules, undoes the rules by the previous regime. Eventually, the executive branch takes over the independent agencies because they appoint enough people. There's a lag. It's like a 1 or 2 year lag, but eventually the Republican president puts enough Republican appointees on a commission, and the Democratic president does the same thing. And so our president was supposed to be a law executor. We don't think of the president as a law executor anymore. We basically think of the president as a legislative person who comes into office with an agenda, who does stuff in 100 days, and who's basically legislating throughout their term via regulations. And so that's a tremendous change, right? Congress is kind of on the sideline because Congress finds it impossible to retract this authority after the president exercises, because the president has a veto. The Congress has given away its authority and is just helpless when the president basically does things that either a minority or even a majority of Congress disagrees with. That's not, I think, a necessary function of the New Deal. You know, the New Deal had other visions of, you know, societal goodness, right, like Social Security and other things that didn't require delegation. But if you believe in the idea that the Congress should be delegating because it doesn't have time, you are again empowering the president to do things that the founders never thought presidents would be doing, right? That there is the grant of legislative power to Congress and not the president.
I agreed with that when I was in the state legislature. We gave very narrow rulemaking authority to executive agencies. And while I was in the legislature, we actually had a Democratic governor that we tried to get along with, or at least pretended to get along with. And we jealously guarded that. But there are a couple of differences. One is North Carolina is much smaller than the nation as a whole. The scope of what we regulated through legislation, what we addressed through legislation, was much narrower. It was a much less complicated system, and the legislature was not dysfunctional. It may be now, but in the 90s when I served, it was not. One of my colleagues, a former colleague's son is here in the legislature. So it was a very different proposition. The term, it takes an act of Congress, I've heard that all my life. I'm sure all of you had too. It now means something, I now really understand that in a visceral level. It takes an act of Congress means it is really hard to change the law. And the other committee assignment that I had, Oversight Investigation Subcommittee Chair for the Finance Committee, but I was also the Finance Committee. A lot of what is called innovation in financial services just means changing practices enough to evade existing regulations. And there's inevitably a delay by the legislature or by the regulatory agency to address new practices. But if it required legislation to address each new practice, it would be no regulation would be possible. And the industry that wanted very narrow rulemaking powers, Dodd-Frank and any other regulatory authority, didn't do it because they believed in the executive branch powers and the separation of powers and protecting legislative powers. They wanted that because they knew they could screw up the works in Congress and prevent legislation from being passed, and they could use new practices. Is this working?
Congress, I think Erica wants to jump in.
I would love to hear.
I'm sorry. It would take years and years, and that is exactly what they wanted. They could make a fortune with practices that were obviously against the spirit of what Congress enacted, and against public interest, and it would take years for Congress to act if Congress ever acted.
So I think Professor Prakash and I probably have different perspectives on the value of some of the things that the agencies are doing, but we share, I think, a view that there has been that Congress should be doing more, and that nobody is well served by laws effectively via these regulations that bounce back and forth every 4 years. That's not rule of law. That's not a regulatory environment that's good for much of anyone. And so I'm curious, Representative Miller and others, if what if you were king or queen for a day? How would you reform Congress? Is it staffing? Is it resources? Are things so culturally dysfunctional that they're not fixable? To help it do more of this legislating and help it make smart decisions that might make the American people more comfortable in putting more power there.
How to fix Congress is a broader discussion. I could talk for long. It's obviously something I've thought about, but it takes and as much as our political culture needs to change. I mean, in Washington, the Washington political establishment, the national political establishment of Democrats and Republicans alike, don't want a powerful Congress. They don't want to have to go to the Hill and talk to these rubes who were elected from out there in America. They want to talk to someone who's holding executive branch power, who's going to be there for 2 or 3 years, and then go back to Covington and Burling or wherever. It's a much bigger issue on how to fix Congress. There's a term, I think, service interruption, service. There is a term about computers of so overloading someone's computer capacity that it shuts down, and that's an intentional attack.
A DDoS attack.
What's that?
A DDoS attack. DDoS.
Okay. And that stands for what?
Distributed denial of service attack.
Okay. Well,
Erica, man.
the important the effect of congressional fundraising is like a EDOS attack. Because congressmen have no time to think about anything else, and that's a problem. I mean, we've had a lot of the leadership in this. I mean, certainly before the Civil War, the great leaders of our country were not presidents. They were members of the Senate, but they were members of Congress. And over time, I mean, members of Congress have played an important role in things. I mean, the Wagner Act was the National Labor Relations Act was one of the most important New Deal bills, and it was called the Wagner Act for a reason. I mean, Wagner really wrote that act, and senator from New York. But there has certainly been an effort, and when Gingrich became Speaker, he cut back a lot of the funding that was available for members, rank and file members, or even committee chairs, and concentrated more of the power in the Speaker's office. That was very intentional, but it very much limited Congress's ability to deal with things. I mean, when the financial crisis hit, we were entirely unprepared for that. We had not a single hearing on many of the issues that had caused the financial crisis. And that was very intentional. I mean, who the hell wants a bunch of congressmen asking questions about derivatives and swaps? It's a bigger issue, but we need a functioning Congress. We need better than we've got.
And I just want to note that I want to hear from Victoria, and there's another panel that focuses directly on the powers of Congress, but I want to hear your thoughts about this. Sure.
Yeah. I also have to warn that I have a class at 10:35, so I'll be running out at 10:30, and I just don't want to be rude, but my students will think I'm rude if I don't show up. I just want to say the first thing to do is not to diss Congress. People constantly say it's sausage, but if you cross out Congress and put in democracy, it looks a lot better. People use the word politics to mean all sorts of different things. Politics can mean partisanship. It can mean fraud. But it can also mean democracy. So start thinking about what you mean by politics, because it could mean it's a vessel in which people put many, many things. I've interviewed a number of members of Congress. I worked there in the 90s. Those are the days when Joe Biden would loan me to Orrin Hatch. Those days don't exist anymore. People have, and I've interviewed them since then, and basically they're elected to hate Congress and to tear it down. The Senate's norms have changed dramatically. Watching the impeachment hearing was just an example of how partisan that body has become in a way traditionally it was not, in part because of a permanent filibuster. There is still a permanent filibuster for legislation, which requires 60 votes. People don't even know that. I'll just give you one short example and then we can move on. But I went up to Harvard for a legal education conference because I teach legislation. I'd prefer to teach constitutional law, but not enough people teach legislation because law students don't know how their government works. They don't know that because it's not taught in political science, and basic civics is no longer taught in undergrad, in high school. So I asked the assembled group of very poobah-ish Harvard professors what was the most important rule in democracy, and no one said anything. And then I said, well, I'll give you the number. The number is 22. And then someone in the back of the room said, oh, interpleader. Interpleader? Really? That's a complicated civil procedure rule. Rule 22 is the rule in the Senate for cloture. It's the only thing that can close debate because there's a permanent baseline filibuster. All you have to filibuster, you don't have to talk the telephone book. All you have to do is raise your hand and say, I object. And then get about 16 others to file, you got to get 16 people to file a cloture petition. That is the background bargaining norm. So if you have a very partisan society and there's no room in the middle to bargain about it, you won't get anything. There is, happily for libertarians, our system of separation of powers has a libertarian default. It's very hard to get anything done. That means that we're very stable. That's a good thing. One civil war, no real dictators.
So
Let's move on. And the problem is it also entrenches horrible things like race and sex discrimination.
Well, I don't necessarily want to move on. I want to sort of bring this a little broader to the point that was made earlier about democracy and how democracy has worked because the people have made it work. The people express their views through elections. They elect the president. They elect the members of Congress. They've elected these lawmakers who are a very, very partisan place right now. And the folks that are in office now look very different than the folks that were there a decade or two ago. So talk a little bit about the role of the people. You say that was as it was designed. Can there be a course correction so long as that's where the power lies?
Undoubtedly, that is the problem. Our political, I think the problem with our political culture may be a bigger problem than our constitutional issues, is that a great many Americans now can kind of take democracy or leave it. We need to make democracy work, Americans have to want to be a democracy. And a great many now only are okay with elections if the right candidate wins, if their candidate wins. And the word tribal has become kind of a cliche, but it's kind of true. And it's very difficult to get past that. And I think part of that has been an intentional effort to divide the country, which would freeze the ability of government to function. But we've got to fix that problem in the culture, or it's not just that Democrats hate Republican politicians and Republicans hate Democratic politicians, although I got a fair amount of that towards the end of my time in Congress. It's that Democrats hate Republicans and Republicans hate Democrats. I mean, there may be some exceptions, to the guy who has a cubicle beside you or your neighbor who lets you borrow their lawnmower. But generally, it actually goes beyond the politicians now, and that's troubling.
Cy, what are your thoughts?
Oh, I completely agree with the congressman. There's too much polarization in America, but it's hard to figure out how we would fix that here. But I do agree that that people sometimes take the darkest view of their opponents, both outside of Congress and inside of Congress. I think, I think it's heartening that I think there are people across the spectrum that are thinking about what our democracy is becoming and what what we're making of our constitutional system. I guess I'd say one other big change in the presidency is that we expect presidents to run on a platform of promises, and then they feel pressure to meet those promises. Why did Obama do DACA and DAPA? He felt like he had to satisfy a base who he made promises to, and I think that's true for Trump and his wall. That he felt he had to show some now I don't know. He may just be building one section of a wall somewhere. I don't really know, but You know, if you go back to the first, dozen presidential contests, they're not making any promises because they don't view the job as making legislative promises. It's really about being an executive officer and defending the country. But we have a totally different conception of the president, right? We expect policy innovation. We expect Medicare for all or a wall or any number of things. And if you don't run on a policy platform, you won't win. And then but that creates pressure on the president once he or she gets into office. So, I mean, I think it's great that Victoria thinks that DACA and DAPA were wrong. I'm more sympathetic to it. I think it's a function of if you give the president a set amount of dollars to enforce the borders and it's not enough to cover deporting everybody, it's not surprising that he can't deport everybody. We see this from our police officers and other people. They don't catch every single person who they possibly could because they don't have enough resources to do so. But that's a function of the discretion that Congress conveys to the president, either in the form of insufficient resources or in the form of statutes that give authority. The word deferred action, my understanding is that's in a statute passed by Congress. And the work permits is also in a statute passed by Congress. So I don't think it's as completely lawless or problematic as perhaps Professor Norris does. The scale of it was unprecedented, but the tools were in the statutes, and again, it's Congress just saying, "You deal with this. We don't want to create precise rules. You deal with it."
Well, I don't think that's true. But basically, they had never addressed that. There is a bipartisan bill that just had 59 votes, not 60. This is why people are calling for the end of the filibuster, right? That is something that can happen. But I just want to say one quick note, and then Erica can.
After that, I'm going to throw it to questions.
Okay.
Yeah.
I do think since Kennedy or maybe since Roosevelt, we have expected presidents to say these things. And unfortunately, I think it's a fraud. And I'm a Democrat, but it's a fraud when all the Democrats say these things that they can do when you have a Senate that is a permanent filibuster. You're not going to get Medicare for all. There's no way. He didn't even get a vote. Bernie didn't get a vote on his public option when he had a chance. And I'm not out here campaigning. I'm saying they all are saying these things. If the Senate does not go with your party, Obama had 2 years, just 2 years. And then when I went into the White House and I asked a very important person, "Oh, what legislative initiatives are you doing?" They said, "We don't legislate." What they did, they had a lot of celebrity, meetings. I mean, I love Obama, but, it was a celebrity presidency as far as I'm concerned. I was looking for a legislative, a joinder of the two bodies, which is old-fashioned, and apparently not what presidents do anymore. But this is why people are cynical, because when I agree with, we disagree about DACA and DAPA, but I do agree that the promises that presidents make, if people think that presidents can do that on their own, that's ridiculous.
I want to bring the audience into the discussion. If you have a question, please let us know and we will pass a microphone.
Thanks. This was really a very impressive and exciting panel, and thanks to you all. I think I'd just like to ask anyone to address this question. Isn't the growth of the presidency relative to Congress really something that Congress has been utterly complicit in? And there are socio-political reasons for this, which we really can't address. But the text of legislation is certainly something that lawyers can think about. And for example, with respect to DACA and DAPA, I have to say I think that the statutory case for supporting the legality of both of those programs is very strong. I mean, for example, there's one important provision in the immigration laws that says that the Secretary of DHS, previously the Attorney General, shall set immigration enforcement policies and priorities. I think that's a direct quote. What part of that delegation doesn't want to understand? So Congress has gotten in the habit of passing extraordinarily broad authorizations, and perhaps that can be changed, but
And
it's
I
also
just
due to
want to
other
make sure we
things.
have enough time for everybody
sorry.
to
I'm
ask
sorry.
questions,
So I just
but I
wanted
want to
to
give you
have
guys
that
a chance
addressed.
to respond to that thought.
I completely agree with the claim that Congress is complicit in the sense that Congress delegates, and we all know that, we've already discussed that, but also in the sense that Congress is funding the institutions that are denigrating congressional power, right? That is to say the White House office and the Office of Legal Counsel, while they're gutting their own staff, as Congressman Miller said during the Gingrich era. There's no reason why, staff in Congress shouldn't be paid more and there shouldn't be more of them. How can you face a behemoth in the executive branch with the minimal staff that Congress has? It's just utter nonsense. And even worse, the staff changes, right, with the committee chair changing and the party changing, right? So if you're in a majority staff in the House now and then the Republicans win, all those people will get fired, say for one or two people, because they're committee staff and the committee is now held by Republicans. There's no reason why Democrats and Republicans just can't have permanent staff that go from Congress to Congress, and you don't have to fire a bunch of people every 2 or 4 years just because the Congress has changed hands. I think Congress is basically unilaterally disarmed in the face of a very powerful president. I'm sorry, Vic.
No, I completely agree, and I'll jump in with an example. I spent some time working for Senator Leahy when he was chair of the Judiciary Committee staff. Adored his staff, respected them enormously. They were very, very smart and committed and worked really, really hard. And they were working on the USA Freedom Act. And it was like one or two staffers up against the entire federal bureaucracy on surveillance reform. There is no way that it's not feasible for one or two people to be able to legislate as much, all the respect in the world for them, with the knowledge and expertise that are necessary against a bureaucracy that has all of the information, and it is thousands, probably tens of thousands of people large.
More questions?
Just on the last point, there are long-term trends in legislative capacity and the capacity of Congress to do its work. We are operating right now at a low point, right? There's been a great diminishment in the capacity of Congress.
Can you speak a little more clearly?
There has been, as the folks recognize, over the last half century, a great diminishment in the capacity of Congress, legislative capacity, staff capacity, whether it's congressional institutions or just the committee staff themselves. I'd be interested to hear, part of the problem seems to be the willingness of Congress to invest in itself.
That is part of the problem. It's not all the problem by any means, but that is part of the problem, that Congress has been stripped of a lot of the capacity to research, to develop legislative proposals. But there's also, Victoria said we shouldn't diss Congress. It's kind of hard not to diss Congress, but I've served there. Believe me, I understand. But we shouldn't dismiss the role of Congress. And if the people who are in those jobs now aren't suitable, let's elect some new ones. The balanced budget amendment is basically saying by Congress, we are way too simple-minded, we are way too corrupt to actually enact legislation, so there needs to be a constitutional amendment to take that power from us. But there is an effort by the political establishment, which is deeply tied to the economic power, to make Congress less where decisions are made. When I was working on Dodd-Frank, I thought that the Obama administration's original proposal lacked ambition, was not as strong as it should be, and I ran everything by that we were doing, that my office was doing, that I was proposing by the Obama administration, which I later learned sent everything to Rajan Cohen, the senior partner at Sullivan and Cromwell, which was itself kind of a problem. But I asked my legislative staffer, my banking staffer at one point, did you run this by the by Treasury? And he said, yeah, of course I did. I said, what did they say? And he got kind of irritable with me, which is, if you're a congressional staffer, that's not really a good idea. Don't show irritation to your member. But he said, they say what they always say. Why can't he just go along with what we proposed? Well, because it wasn't very good. And there was also sort of the sense of where he did car wreck cases out in the provinces. Where does he think he should? Why does he think he should be involved in this discussion? Article 1 of the Constitution. I put my name on a ballot. I got more votes than anybody else. I know it was out there in the provinces, but still, that's where political power is supposed to come from.
Any other questions back here?
Yes, my question is about conceptions of separation of powers, particularly concerning prosecution. I know Congressman Miller and Professor Prakash both commented on the notion of prosecution. My sense is that if you look at the first Congress, they had a very subtle and differentiated approach when they created the enabling legislation for different agencies. In, say, foreign affairs and the Department of War, where it was clear the presidential authority was primary in the Constitution, they gave the president significant latitude to organize the agencies. But in the Department of the Treasury and also creating the Office of Attorney General, it was very different. On Attorney General, there was really no presidential or control of the Attorney General of federal prosecution. Congress reserved this to really other departments. The Attorney General was part-time with no staff. Given this, I'm just wondering, or would like to know, particularly in reference to your suggestion, Congressman, that the courts have the authority to appoint prosecutors, that Congress does the same. It would seem to me that this historical experience would be favorable to that, and that criminal prosecution is one of these areas, especially in the realm of contempt, where there isn't unitary executive control.
I mentioned I wrote a piece last fall, but there's a piece that I just wrote that's up this morning in American Prospect on what reforms I think there should be in checks and balances to deal with what we've just seen. And congressional oversight is pretty basic to Congress's ability, and there's 200 years or more of court decisions and democratic thought, and before that, the British Parliament and the colonial assemblies had subpoena power to inform itself. And I think Wilson, writing as a political scientist, he was probably a better political scientist than he was a president, said, they called it the informing power of Congress, and said it was more important than the legislative power. The power to tell the American people what their government is doing. And if they don't know what their government is doing, their right to vote doesn't mean much. And that is why I'm so disturbed by the Senate's vote and the House vote, is that Trump, it was not some kind of narrow legal argument about executive privilege, which remains ill-defined, but certainly doesn't, there's no support for it going as far as they say it goes. It was that the administration is not going to answer any congressional subpoenas. I mean, he said that almost immediately after the 2018 election. We're going to fight all subpoenas. And that's a pretty big claim of power and an attempt to strip Congress of what has been a foundational power for the entire life, the entire history of our republic. The very first, the first Washington administration, there was a military disaster on the far western frontiers, Ohio, and Congress investigated. And the Washington administration, Washington assembled the cabinet, and they said, you know, we really don't have to give you this information that you have demanded of us. I don't think they called it a subpoena then, but it was essentially a subpoena. But we're going to give it to you anyway. And that's sort of been the pattern. That's set the pattern for the entire history of our republic is the president say, we don't have to give you this, but we will, or negotiate. There's a lot of jostling about what president provide, but fundamentally, Congress exercises oversight power, subpoena power, not just to inform itself, but to inform the American people. And that's basic to democracy.
If I could just jump in, I think you have the history wrong, actually. The Attorney General, the name comes from the phrase general attorney. It's not a general in the Army sense. So the fact that the Attorney General had no authority over the prosecutors didn't speak to whether the president did. And as I said earlier, the president actually directed prosecutors all the time in the states because they worked for him, not the Attorney General. There was no Department of Justice. There was just an Attorney General and prosecutors. The Attorney General operated in the Supreme Court and the prosecutors operated in the district courts. So there's a myth that because the Attorney General couldn't control the prosecutors, the president didn't have any authority. But I have an article called The Chief Prosecutor, which describes exactly how Washington controlled all these folks. Now, so it may be that times have changed or we should have a different conception of it, but the original conception is that Washington controlled prosecutions. He told people to start prosecutions, and he told them to start it. The most famous instance of this is the Neutrality Proclamation, where he says, I've given instructions to prosecutors to prosecute Americans who violated our peace treaties with Great Britain and France.
We have time for one more question. I'm going to go back here.
So a very short comment and then an even shorter question. So the comment is for Erica. As bad as the balance between the staff and the executive branch is that you refer to, it's actually much better today than it has been at other times. And so, for example, in 1947 and 1948, the chair of the Senate Foreign Relations Committee had one staff member and a typist, a secretary, and the Senate Foreign Relations Committee had one permanent staff member. And today, there's you and your colleagues, and you're doing a much better job. You were able to do a much better job than they were able to do back then. They were really at the mercy of the executive. So the question is, based upon everything that you guys have said, would you support doing away with the filibuster, Rule 22, and why or why not?
I would, with great regret, because I think Congress is not functional. The understanding of the old filibuster was a different culture that somebody who worked, I think it was for George Mitchell, so it's been some time ago. When a member of the Senate put a hold on something, after a while, Mitchell would give him a call and say, look, we need to move this bill. Let's talk about why you're against it. And there might be some jostling, some compromise, some amendments, and I'm okay with that. Everything I've ever worked on in the state legislature, where I got a lot more legislation through than in Congress, was compromised. That didn't happen anymore. And it is used as just a roadblock, a full stop to legislation. And we aren't a well-functioning democracy right now, and we need to do something about it. And I would favor the repeal of the filibuster.
Sai, what do you think?
No, I completely agree. I think the filibuster is being abused now, and the number of times that people try to invoke, the ability to speak indefinitely has gone up tremendously, and they don't have to pay a price for it because they don't actually filibuster, right? They just threaten to, and then the majority just caves in, and so they basically incentivize people to be bad actors because they never make them pay a price for it. And the end result is that there are many more situations where people just say, I have an objection, and then they just table it. They don't even bother making them go through the filibuster. So we already have what I regard as a supermajoritarian process. We have the House, we have the Senate, and we have the president. It's very hard to pass legislation even without the filibuster. So, as much as I understand why senators want the filibuster, especially if you have idiosyncratic views, I don't see why the rest of the country should be held hostage to the views of one senator.
Erica?
I'm going to be really frustrating here. I'm inclined toward it, but I'm not completely toward saying we should abolish the filibuster. I'm not completely convinced. I don't. Professor Prakash's point about how it's not used in the same way that it was a generation ago is, I think, absolutely right. I don't think we should fetishize it as all that is wrong and use that as an excuse to not do other reforms. And I wonder, I don't feel like I have the perspective on, often partisanship is used as an excuse to get rid of the filibuster. We're talking about a numbers game, 50 versus 60. Is there something about our system that leaves us at approximately a 50-50 Senate at all times, and therefore getting rid of the filibuster changes how majoritarian the Senate is? Or is that kind of an accident of where we are in history right now? I don't feel informed enough to have a firm view on that.
We're probably running out of time, but the legislature in North Carolina worked completely differently from Congress. When I first got here, I talked to Marion Barry. Now, there are two American Barrys in American politics. One was the drug-addicted former mayor of Washington, not that Marion Barry. The other one was a good old boy congressman, now former congressman from Arkansas. And I talked with him about how he had gotten involved in politics. And he was a rice farmer. His brother and he were the two biggest rice farmers in Arkansas. And the young governor of Arkansas, Bill Clinton, introduced a water management bill. Rice farming involves an ungodly amount of water. And Marion and his brother didn't like the bill. So they went to Little Rock and they went to office at the legislature, and they killed it. And 2 years later, President Clinton, then Governor Clinton, introduced the same bill again, or got someone in the legislature to introduce it for him, and they did the same thing. They went to Little Rock, they got it killed, and then Bill Clinton called him up and said, look, you've beat me twice, but I may get that bill through one of these times, and you're going to be stuck with it, and you're not going to like it. So we can either keep doing this, me introducing that bill and trying to get it passed, and you fighting it every time, or you can come down here to Little Rock, and we can talk about it and see if we can work something out. And Marion Barry went to went to Little Rock and worked something out with Clinton. And after that, he and Clinton were fast friends. And when Clinton was elected president, he appointed Marion Barry to some fairly responsible position in the administration. And when the congressional seat came open, for the district that Marion lived in, everybody thought Marion ought to be the guy. That just doesn't happen. And I thought, when Marion told me that, I thought, I can do this. This is, that's what I did in the legislature all the time. I can do this. Congress doesn't work that way at all. And actually, some of the worst offenders were people who got their start in the Clinton administration, oddly enough.
Well, we can talk on and on about this, but there are more panels, and I want to give our audience a chance to join me in thanking our panel today.
Hello, everyone. I'm David Blumenthal. I am the chapter liaison for Georgetown ACS student chapter, and I'd like to thank you all for being here today. I hope you all enjoyed the terrific panel this morning, and now we've got another great one planned for you. It's my honor to introduce Mika Oyang, who will moderate our second panel, Protector-in-Chief, Co-option of National Security by the Executive Branch. Mika is the Vice President for the National Security Program at the Third Way, committed to closing the credibility gap between Democrats and Republicans on security issues. Mika works on every major national security issue, from foreign policy to cybercrime to impeachment. Before joining the Third Way, Mika served as Chief of Staff to Representative Anna Eshoo and Defense Policy Advisor to Senator Kennedy, among other positions on the Hill. Her thoughtful analysis is frequently solicited by major media outlets, both print and television. We are so grateful to have her here today. Please join me in welcoming Mika Oyang.
Thank you, everyone. And I want to quickly introduce our panel. And they have such interesting things to say that, can you guys hear me? that I think we'll jump straight to questions and the conversation, because I feel like we've got a lot of interesting commentary. Oh, all right. Sorry. I'm used to being actually mic'd, so it's weird to like hold a mic. But before we start with questions, I just wanted to like remind everyone a little bit about the national security powers as set out in the Constitution between the different branches, right? The Constitution gives Congress the power to define and punish piracies, felonies committed in high seas, offenses against the law of nation, to declare war, issue letters of marque and reprisal, make rules concerning captures on land and water, to raise and support armies, but no appropriation for use of money longer than 2 years, to provide and maintain a navy, to make rules for government and regulation of land and naval forces, to provide for the calling forth of the militia, to execute the laws of the Union, to provide for organizing, arming, disciplining the militia, and for governing as such part of them as may be employed in the service of the United States, reserving to the United States the appointment of officers, the authority of training of the militia, and to discipline prescribed by Congress. As for the president, all the Constitution says is, the president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. That's it. But over time, we have seen the president become much more powerful in national security, a trend that has only accelerated after 9/11. And while it's easy to blame the accretion of executive power on the current president, we've got a lot of trends that have been a long time in the making. So with that, I am going to turn to my panelists, Marty Lederman, a professor of law here at Georgetown, Bijal Shah, a professor at Arizona State University, Jean Healy, vice president of the Cato Institute, and Hina Shamsi at the ACLU. And Hina, let's start with you. Congress has the power to declare war, but yet we've seen very few declarations of war, the last one in World War II. We've seen some authorization for use of force, the last one in 2002. Talk to us a little bit about what's happened in Congress and their attempts to try and regulate the executive in its authorization of force.
Sure. And thank you very much, Mika, my co-panelists, and to ACS for having this discussion. So in response to Mika's question, I don't know about you, but these days I try and look for some level of good news wherever I can find it. And last week, Congress actually did a good thing. I actually had to check my calendar that it was last week because it feels like years ago. In that the House had 2 votes. One was to revoke the 2002 authorization for use of military force, which had authorized, in essence, war against the Saddam Hussein regime in Iraq, and a second vote to block funding against military action in Iran. Now, as these things are wont to do, those 2 resolutions passed the House largely along party lines, but they reflect something of a small but still significant trend following an effort last year, building on sort of years of effort, to rein in the president's authority to provide support to Saudi Arabia, which has been engaging, as you all know, in some horrific activities contributing to the disaster situation in Yemen. And so what we have here, and I told you it was glimmers of good news perhaps, is Congress finally beginning to assert authorities and flex muscles that it hasn't, not just not doing so largely in the years since 9/11, but also well before, in terms of exercising one of the express powers given to it under the Constitution, the power to declare war. And this expansion, of this sort of trend in which Congress has failed to act has been accompanied by, of course, a trend that is very familiar, the expansive claims of executive branch authority, especially in matters of war, starting with Article 2 authorities, theories of commander-in-chief powers that are authorities claimed by both Republican and Democratic presidents. So when we think about this and when we think about reversing these kinds of trends with respect to accretion of power by the executive branch and abdication of power by Congress, this is a bipartisan thing that requires bipartisan solutions. I would be remiss if I didn't mention the courts very quickly here before I come back to the theories and the consequences. The courts have largely, or at least the Supreme Court after during essentially the Bush administration period, have written themselves out of the equation. The Supreme Court has not weighed in on these claims of authority, and when the claims of authority are brought into court, which has largely been in cases, for example, that we've brought at the ACLU with respect to people who've been detained under these powers in a variety of different theaters, or when the president has claimed the authority to kill American citizens using these powers, they've often been dismissed at threshold stages based on arguments or acceptance of arguments on standing or political question. So going back then to the executive branch, claims of authority are based largely in the post 9/11 era on the argument that the 2001 AUMF goes far beyond its original purpose, which was to address those responsible for the 9/11 attack. The argument sometimes combined with it with respect to the 2002 AUMF and additions of concepts of associated forces that are often inadequately defined or broadly expansive, and in some situations kept from the public in terms of who those associated forces are that the executive branch claims the authority to use force or go to war against. And then with respect, so those are the two statutory, largely the two statutory sources of authority, but then the congressional or the constitutional arguments are also really expansive, really disturbing, and really dangerous in terms of claims of sort of a combination of, and I'm simplifying a bit, sort of inherent authority when Congress hasn't spoken, combined with commander-in-chief authority, which is not very well defined at all. And there, I think we see perhaps the most recent articulation of it with respect to the strike against General Soleimani, with which we started the earlier part of the year. And with respect to that, we've seen varying, inconsistent justifications that call upon both statutory claims as well as constitutional claims. Statutory, early on, in articulation of claims of authority to use the 2002 AUMF against Saddam Hussein's regime as justification for killing Soleimani in Iraq, but also varying notions of the authority to act in response to an imminent threat. And here I'll just pull out another theme, which is that notion of imminence, because where that comes from in part is under, well, it can come from different places, but the War Powers Resolution, which is supposed to restrain executive branch authority, recognized the president's power to respond in a true emergency, in response to a true imminent threat. And one of the problems is that the War Powers Resolution never defined imminence. And that claim of imminence, combined with the claim of imminence as justified under international law, has been stretched by Republican Democrat administrations alike, and goes into sort of a notion of potential response to a potential attack, as opposed to a concrete, specific, imminent thing that necessitates response without, in a period of time where Congress wouldn't have the power to act. That's one of the things that I think needs fixing, and maybe at a later point we can talk about how the regime of regulation and conversation as between the branches, particularly the executive branch and Congress, has broken down, and what some of those fixes might be, given that one of the primary fixes, the War Powers Resolution and the War Powers constraints, have shown not to work and in fact are broken.
Yes. We should definitely get into that. But first, Jean, the other big power that Congress has, other than declaring war, is the power of the purse. And we have seen in recent era the president acting, in express opposition to Congress's direction and spending. Right? We think about sort of Youngstown Sheet and Tube, that when Congress gives them specific instruction that they're supposed to act a certain way. But with both the expenditure in Ukraine and then the diversion of DoD funds to build a wall, we've seen the president act very differently in this, including in some cases an invocation of emergency powers. Talk to us a little bit about what this means that the president is starting to act in this way on the spending power of the United States and using his emergency powers to do that.
Yeah, I think this is one of the areas where, thank you. I feel like Phil Donahue here. I think this is one of the areas in which Trump has been something of an innovator in a negative sense. It's kind of tough Trump himself is so distracting that it's kind of tough to separate signal from noise because he tends to hit send tweet on crank theories of executive power, like, can the president pardon himself? And a lot of this stuff ends up not happening. And it seems to me, to wind up to your question, if you try to separate signal from noise, a lot of what has happened in terms of the Trump imperial presidency is aggressive use of authorities that his predecessors had already left to him. You mentioned the 2001 AUMF, the expansion of those authorities. And we bracket the Soleimani strike because I think that is something genuinely new. But even in things like the 2 drive-by bombings of Syria, they rely on and quote from in the Office of Legal Counsel memos prior justifications for the Libya war in 2011. But where I think Trump has actually been dangerously entrepreneurial, one of the areas is with national emergency powers. He certainly, we've 30 plus ongoing national emergencies, certainly not the first president to declare a national emergency. But he is, I think, the first president to declare a national emergency in order to get access to funds that Congress would not appropriate for him to build the wall. And he did that by citing obscure statute, the Military Construction Codification Act, that if you look at it, its prior uses had sort of been to divert Pentagon funds towards something that toward a national emergency that requires the use of armed forces. It had been used, I think, in the run-up to the Gulf War in '91, and again after September 11th. It seems never to have occurred to a prior president that you could use emergency powers lauded throughout the U.S. Code to do an end run around Congress in a budget battle. And it seems to me that's quite dangerous, and it may not be the last time we see something like that. So Trump has this effect of sort of concentrating the mind wonderfully on some of the mistakes Congress has made by delegating too much power to the executive. And one hopes that this experiment we're running through will concentrate the mind on how to take back some of those authorities.
And while Trump may be an innovator in using the spending power, he's certainly not necessarily an innovator in trying to make an end run around Congress. We've seen presidents trying to act via executive authority to do things that Congress wouldn't otherwise allow them to do in other areas, particularly in immigration. Bijal, President Obama implemented the DACA program via executive order, and then we've seen President Trump take that executive power in immigration and really expand sort of his authority. How do we understand sort of the ways in which presidents, have used their power in this way in immigration, which has typically been something that was reserved, that Congress dealt with in statute?
Yeah, so several scholars, including notably Adam Cox and Christina Rodriguez, have written on how, while the Congress sort of creates legislation and controls the front end of immigration, the president has power over the back end in how that legislation is implemented and consequently how immigration priorities are sort of developed. And so certainly this is not new under Trump. Under George W. Bush, we saw the detention after removal hearing program, which was the immediate detention of anybody found removable in a hearing. Under Obama, as you mentioned, we had the DACA program, which allowed the government and agencies to sort of prioritize how they would implement legislation and go after a certain group of folks before they went after another group in their efforts to enforce the law. We also see initiatives lower than the level of the president that shape the implementation of legislation. For instance, one longstanding example I remember from my days in the government was national security holds on asylum applications that were otherwise granted, and these would be sort of held in limbo, determined by Department of Homeland Security and held in limbo for periods of time. Another that I've written about is the referral and the remand and referral power, the Attorney General's power to sort of take over immigration decisions and change them, often in order to adhere better to the president's agenda. And so this is a thing that's been happening for a long time, for sure. That having been said, the current president's efforts do sort of go above and beyond in many ways. So one thing that's unique about his approach is how clearly or how sort of explicitly he's tying what he's doing, every sort of thing he's doing to chip away at the enforcement of immigration, or to sort of enforce immigration in a certain way, to national security priorities. Those are his, that's his sort of way to achieve that goal. Whereas in the past, presidents may have thought that supporting allies at war, providing aid to under-resourced countries, and so on, were forms of national security, forms of ensuring national security. This is not this president's approach. And so I have it written down because there are so many things that are happening that it's, we have, by executive order, we have the family separation policy, and we have the travel ban, which again has been extended just recently. We also have the reinforced executive order. This repeats something that was in the original travel ban, but the reinforced executive order to support state refusal of the resettlement of refugees, which hasn't worked out, I guess, in his favor because a number of red states have actually explicitly said that they will continue to resettle refugees. We also have other forms. So executive order is not the only way of expressing presidential power in the immigration context. We have policies that the president and attorney general have implemented to sort of require quotas of immigration judges, who have then pushed back by saying, this is going to reduce the quality of our decisions and make them less likely to be upheld in the courts. We have regulation. And so the regulation that I'm thinking of, the regulation that expands the term public charge to reduce access for immigrants that are already settled in this country, is symbolic of kind of another new thing that this president is doing. And so while previous presidents have certainly shaped the implementation of immigration enforcement, once non-citizens have documentation, presidents have sort of left that alone. They've allowed the resettlement process to continue. They haven't interfered with access to public, benefits or access to domestic travel. So this is something sort of new. This this interest in interfering with the the lives of non-citizens once they've already been granted status. And so one is this regulation, which again seeks to expand the term public charge in legislation, which has been in the legislation since the late 1800s. And another is, let's see, well, various, resettlement initiatives, as well as we're even getting to the point where there's additional vetting of citizens who are Iranian at the airports because of recent, because of the tension between these two countries. And so, yeah, I mean, I could go on, but there's a lot to grapple with.
Very long list.
Yeah. So,
yeah, and it's very clear that like the president's acting in this and other areas in express contravention of Congress's intent. Marty, the enforcement mechanisms that Congress has typically engaged in to express its discontent, to work with the executive and national security, have largely been sort of informal, except when they're talking about the power of the purse. Talk to us about how those mechanisms have changed over time.
Is this on? Yep. Okay. Well, thanks for ACS and for my fellow panelists. It's a pleasure to be here. I mean, what's really interesting listening to my fellow panelists talk and to your question is sort of the premise of the panel is Congress has become quiescent. The president is acting unilaterally. That's the theme of the conference and all that. And yet, with some exceptions that we'll get into that Hina raised, most of the more controversial things that this president has done, and for that matter, previous recent presidents have been done pursuant to claims of statutory authority. And as it turns out, really, when you look at the wide swath of congressional action since the Korean War, over the last 70 years, turns out there's actually a bunch of statutes that regulate the president or that authorize the president or executive branch actors to do a bunch of stuff. And statutory interpretation rather than constitutional law turns out to be 9 times out of 10 where the real action is. And so I want to suggest, I guess we'll get more into it in our conversation, be careful what you wish for in terms of hoping that Congress would impose greater restrictions on the commander-in-chief. Right, I'm not sure. I think we should talk about, for instance, the Kane legislation to stop the use of force with respect to Iran, how difficult that is. And do we really want Congress engaging in lawmaking? Do we want the United States Congress to approve the use of force with respect to Iran? I think that would be internationally a disastrous sort of prospect. I'm not sure that's something we should welcome. And it's very hard to craft legislation that would calibrate when exactly the president should and should not use force in that kind of area. And oftentimes the legislation that Congress enacts, sometimes it's great, right? I've written hundreds of pages about how throughout our history, but especially since 1975 or so, Congress has enacted plenty of laws that pretty dramatically limit what the president can do in wartime and otherwise, and in national security, the Torture Act, FISA, all those things that President George W. Bush claimed the right to disregard. You know, the statute books are full of statutory constraints, but they're not always great, right? So when Congress prohibited the transfer of Guantanamo detainees outside of Guantanamo, that prevented President Obama from closing the Guantanamo, right? There's Congress in action, right? Is that really what we want? Are we certain that we would get good legislation from this Congress? But more often, and this gets more to your question, what we've seen, in fact, I think war powers, roughly speaking, over the long haul, was working. There was a decent balance, and it was mostly because of two things. One, it was because of reasonable constructions of statutory authorizations that Congress had given to the president, and an informal working out behind the scenes between executive branch actors and their appropriators or their overseers in Congress about how those statutory authorities ought to be implemented. And that, as you suggest, I think is changing. The executive branch is increasingly either using very broad discretion that Congress has conferred upon the president, or construing authorizations much more broadly than Congress could ever have imagined, And the usual pushback on that, not through new legislation necessarily, but through threats of cutting off appropriations or just making life hard on you, or the ordinary everyday give and take between congressional committees and the executive branch, the executive is becoming bolder and Congress isn't pushing back in the ordinary informal ways. So let me just give a couple of obvious examples that touch on what my fellow panelists have talked about. So one is all of these new presidential proclamations restricting the entry of people into the United States, starting with the travel ban and now this new one, not even the public charge, which is just the construction of a statute, but the related recent proclamation that people who cannot guarantee that they will have sufficient health care will be excluded from the United States. The president there is invoking Section 1182F of the McCarran-Walter Act, the INA, enacted back during the Cold War, which is extraordinarily broadly written. It gives the president virtually carte blanche authority to keep out any foreigners from the United States if he thinks that their presence would be detrimental to the national interest. That authority was not really abused for 70 years. There was a give and take between the legislature and the president. There were a couple of controversial exercises, but more or less, the president used that authority only when there was some broad consensus that it was appropriate to do so. But it was always sitting out there, ready to be exploited by a president such as the current president to do things for which there wasn't that kind of a consensus. And the Supreme Court has blessed that, at least as a matter of statutory construction now. Similarly, the War Powers Resolution, I'm in the distinct minority here in thinking that for many decades it actually worked. It actually, roughly speaking, created a settlement between the branches, a dynamic that reflected where I think the Constitution, roughly speaking, sits. And it more or less required that if the president thought that a military action would last a certain amount of time and lead to a certain amount of possible risks to American blood and treasure, you needed congressional authorization, which is what you got in the 4 major wars since the Vietnam War. But in more discrete, time-limited things, you didn't have to do that. But then President Obama defined hostilities in Libya very broadly, and Congress didn't push back. And I fear that that definition, that statutory construction, will have the effect of making the War Powers Resolution the dead letter that most other people think it already was. But I actually think that it was performing a great deal of good work. And then finally, let's just take this example of building the wall. So there's been out there since time immemorial, this provision, I don't even mean the emergency provisions, which is only their last stop, their backstop funding. The main thing they're doing is using a provision that's been in appropriations bills forever that allows DOD to transfer funds from one account to another, from an account Congress has prescribed to another account. They said, we're doing that here. We think this statute gives us the authority to do it. I happen to think their statutory construction is somewhat absurd, but that's the least of it, because the rule, the practical rule reflected in a DOD reg was we will not make any transfers without getting the approval of our appropriations and armed services committees before we do so, something that my friend Jay Johnson, who just walked into the room, probably knows very well. Jay was among other things, the chief counsel at the Department of Defense and one of my favorite clients when he was, and he knew that you had to make nice with, engage in ordinary sort of give and take with your overseers, with your appropriators, in order to make a transfer of funds from one to the other. So the Defense Department here went to the Appropriations and Armed Services Committees. They said, we want to transfer these funds in order to build the wall. And there was a bipartisan consensus. That's crazy. No, you don't have that approval. And they said, thank you very much. We wish you would have said okay, but you didn't, and we're going to do it anyway under this statute. And the appropriators in the Armed Services Committee were aghast. You're breaking this decades-long comedy between the branches. You agreed you were supposed to get our approval before you could do this sort of thing. And they said, well, stop us if you can. And so the House, basically everyone on both sides of the aisle said, we will not let this stand. We are threatening you. We are going to get rid of your general authority to transfer funds, to reprogram, if you don't pay attention to what we say you should do here. And that was in the House bill. And then the Senate bill took that out at the request of the Trump administration, and Congress passed appropriations and authorization bills that continue to include this authority. They haven't pushed back on the interpretation of hostilities. They haven't pushed back here. They haven't tried to limit this broad authorization, this broad delegation in the immigration laws. And presidents now know, because of the examples of the last few years, that they can exploit the ambiguities or the actual breadth in these statutes. And there doesn't seem to be the will in Congress to do the work just to work on the informal and actual amendment of the laws, the informal mechanisms, and the amendment of the laws that would limit the executive's ability to read these laws too broadly and to cut out the Congress from the informal mechanisms that have traditionally been used to temper what the executive branch does and to reach consensus across lines. So I think that ought to be where our attention is and where Congress's attention is, rather than in trying to come up with new substantive limits on war making, for instance, which I think is a very difficult chore.
Totally agree, as someone who's tried to draft such
I wasn't blaming you.
I didn't draft.
No,
I'm not.
This
I'm
is
not
one of the best
responsible
at
for any
doing
of
it.
the- I am not responsible for drafting any of the existing AUMF, just to be clear. But you raise an interesting point about enforcement mechanisms and the idea that Congress, when it is upset at something that the president is doing, they have limited recourse, especially if one of the two chambers of Congress is actually going along with the president in his exercise of power. And so we see this in Congress. So where can we look in terms of oversight, or other congressional powers when we think about Congress enforcing or seeking to enforce its powers? And I think one of the areas where we've really seen this challenge come forward is in the oversight power, especially when they're asking for information relative to national security information, whether that is notification about the justification for taking military action, whether that is seeking information about the refusal to expend money in the context of Ukraine. How have we seen the evolution of Congress's oversight powers in this area, and have the courts changed in their view of this over time? Has Congress changed in its aggressiveness to pursue its oversight powers over time? We saw, for example, the Senate Republicans arguing, the president's defenders arguing, that the House managers should have sought more aggressive enforcement of their subpoenas, for example. And I will open it up to the panelists to respond.
I just want to respond, putting this in some context, but then I'd love to hear what my fellow panelists say, which is, this is right now a hugely important legal question before the Supreme Court in the Trump versus Mazars case. The argument being made by the Solicitor General and by Trump's private lawyers would effectively limit Congress's powers of investigation and of subpoena if the court were to adopt the views that they've proposed. And there are more modest jumping off points by which they could rule for the president. It would be a dramatic, it would basically mean that Congress's general oversight is not a legit oversight, determining whether the executive branch is doing the right thing, whether it's compromised, whether it has conflicts of interest, whether the discretion that they're using is being wisely exercised, would be illegitimate, right? The only reason for having oversight, according to the government, is in the service of proposed legislation, and that has to be demonstrated to be the reason for oversight. When you think about the intel committees or the oversight committees, sure, there's always the prospect of legislation, and sometimes it comes about, but that's not what they're doing 99% of the time, and that's not generally how they keep the executive branch in check, through proposed legislation. Perhaps the proposed threat of appropriations cutoffs, but as I was just saying, that threat is now being shown to be empty in this Congress anyway. But I just want you to keep your eyes on this case, because the president's tax records are the least of it. The arguments that are being made are a more profound threat to Congress's oversight functions than anything we've seen in many decades.
On
that wonderful note.
not going to disagree with Marty on that. So if there's anyone who wants to address that point, I wanted to go back to a couple of other points that Marty was making about border wall and war powers.
I'll just say briefly, I'm not to disagree with Marty at all, but to build on, no, truly to build on what you're saying in the immigration context, which, yeah, so your question is, to what extent is Congress engaging in the legislative process in order to shape what the president does or to limit what the president does, and in immigration, not at all? There's been this sort of pact, I think, between Congress and the president to share the plenary power. Seeing some interesting things where the president is now trying to, is allowing for the diffusion of this power to the states, but that's not the question you're asking. Maybe it's the question you will ask. She said, hopefully. But in terms of what Congress is doing, it's not much. They claim that collective action keeps them from making any movements towards the legislation that DACA sought to replicate under the Obama administration, and now we don't have, we don't have the consensus in the Senate to really push back. It's surprising how little oversight on all of these fronts Congress is engaging in. I can't think of anything that has made any sort of news that is remarkable in any way that would suggest that Congress is at all responsive to or at all finds at all problematic any of the president's immigration initiatives. And so, yeah, I guess that
feels very bleak.
It does. Sorry, but maybe we'll end on a better note.
I would just say to Marty's point about oversight and subpoenas, I would just say, when I was on the House Intelligence Committee and we were conducting oversight of the Bush administration, we would draft subpoenas and show them to the administration and say, if you don't give us this information voluntarily, we're prepared to vote out this subpoena. And merely the showing of the subpoena was sufficient to get voluntary compliance on behalf of the Bush administration, as opposed to sue me, right? Like, so it's the sort of informal defaults about how people respond to congressional oversight powers in the executive branch has shifted dramatically.
That's my sense.
Yeah, yeah. And sorry, Hina, you wanted to respond.
Not on that.
So,
yeah.
But the other thing that I think is a real challenge here is the executive branch use of classification and secrecy to inhibit both congressional oversight and public debate about things. And as we've seen in a lot of litigation over various controversial intelligence programs, in the publication of John Bolton's book, in any number of other areas, we've seen the executive branch try to invoke various concerns about secrecy and classification in order to prevent information from getting out there. Are we seeing something new in this administration? How has that evolved over time? Marty, you were in the Obama administration as people wrestled with some of these things. For those of you who've seen the movie The Report,
I'm not in it.
Marty's not in it, but my Senate counterpart is in fact played by Adam Driver. It looked like it was a terrible job. I'm really glad I didn't get it. But we see these attempts to prevent people from getting information that would shed light on what the administration's doing. How is that impacting people's ability to hold accountable the administration, this use of secrecy?
I'd like to talk about that, but let me defer first to Hina and Jean.
So in really significant ways, what we're seeing with respect to secrecy over claims of war authority, other aspects, are a continuation of efforts that we saw in the Bush and Obama years. But in the Bush and Obama years, or certainly by the end of the Obama years, there was some level of desire to potentially entrench the policy constraints that the Obama administration had put in place with respect to expansive legal claims that they had been making in court. And there was, whether through litigation, including our litigation, or through responses to certain kinds of congressional requirements for disclosure, the Obama administration belatedly started producing some level, inadequate in my view, of transparency about the use of force, the legal justifications for that use of force and the consequences in terms of civilian casualties and outcomes. That was expressed less as a sense of legal obligation than a sense of largesse in some sense, having been on the receiving end of that. And virtually all of those kinds of disclosures have been limited or eliminated by the Trump administration. We are seeing more extreme claims of secrecy with respect to policies and procedures and outcomes. So just to give you one example, we were able to force disclosure of President Obama's presidential policy guidance with respect to the use of force outside of what was then called areas and still is areas of active hostilities. It was disclosed as a result of litigation. Early on in the Trump administration, we know from news accounts and some other indications from government documents that those rules, which had purported to put policy constraints on the use of force in order to prevent or limit civilian casualties, had been changed, loosened. And we soon started seeing the consequences in terms of reports of civilian casualty outcomes. The Trump administration takes the position now in litigation that even the fact of whether those policies have changed or exist is a secret. And that the kinds of reporting that the Obama administration used to do, it's de facto not doing. There's some new provisions under the National Defense Authorization Act with respect to civilian casualties. Those were some of the few beneficial things that survived the NDAA process at the end of last year that should require more disclosure, but we're going to see how it goes, because even under the Obama administration, that disclosure wasn't adequate. But I want to very quickly touch on two other points that Marty raised. One is with respect to the border wall. And Marty, you absolutely rightly pointed out the provisions that were stripped at the end of in the NDAA. I want to remind us that we had the nation's longest shutdown because Congress refused to provide President Trump money for a xenophobic project. And then when there was a congressional vote across party lines to rescind that emergency declaration, that passed both houses, and the president vetoed it. So it's not that Congress hasn't been acting. The question is what happens when the kinds of norms that people might have been willing to rely on in previous administrations are thwarted. And we're seeing that very specifically in the border wall context, because we are representing the Sierra Club and the Southern Borders Communities Coalition in a lawsuit challenging this border wall, arguing our case specifically doesn't challenge the emergency declaration, in part because we were concerned about how much deference the courts already give to the executive in this context. We're challenging violations of the appropriations clause, as well as the specific statutory authorities that have been invoked to divert $3.6 billion in military construction funds, $2.5 billion in military pension and other benefits funds. And with respect to the statutory arguments, they are, again, very extreme, but in some sense a continuation of the last 15 plus years, which is a level of argument that says that the judiciary does not even have the ability to define, and there are no justiciable limits when the executive interprets its statutory authority with respect to emergency uses of forces in particular contexts. And so, and we've been up to the Ninth Circuit twice. There's another Ninth Circuit argument in March. And this is a case that may well head to the Supreme Court, but we're also in a trajectory where we now have a Supreme Court that has exhibited, as in the Muslim ban case, extreme deference to claims of power. And that's one pattern. A second is Margie pointed out that Congress hasn't pushed back with respect to war powers and so on. An important part of that calculus and that decision making has been, as Margie will know from his time in OLC, interpretations of executive authority vis-a-vis Congress have largely come from executive branch lawyers, and they have been massively expanding the authority. The few constraints that have been recognized tend not to be constraints with respect to legal limits, but more with respect to policy limits. And so what we're talking about is a really broken system when we're thinking about war powers, national emergencies, the kinds of constraints that might happen. And so my response here is not that it might be, I certainly think it can be dangerous when Congress acts, but it's very dangerous when Congress doesn't act. And what then do the reforms look like? Because the trajectory we've been down is one that really means that our system of checks and balances not only isn't working, but it can't work.
That we're like a very bleak panel today. I got to say, I do think also one of the challenges, Jean, I want to come to you on this, but I do think one of the real challenges here in the legal community, though, is many of the lawyers who work on this area come out of experiences at OLC and DOJ. They're executive branch lawyers. They have had that experience of sort of defending the Article I powers. Very few people are Article II people. I think there are Article II people, not Article I people. I feel like I'm one of the few Article I people.
I think I like all the articles, but yeah.
I'm biased. Article I, no, it's number one for a reason. Anyway, Jean, I want to come back to you on these questions of secrecy, but also, right, you're at Cato, the libertarian organization advocating for small government. Like, is there still a constituency for that among sort of in Congress for this sort of approach on limited government? How have you sort of seen the evolution of an approach that says, hey, we should limit government's power here, and sort of an uptake for that in the legislative branch?
Well, on some of these issues, there is sort of a strange small strange bedfellows alliance of some of the Rand Paul types, Justin Amash before he was sort of defenestrated by his party, where you would see odd coalitions on things like surveillance and war powers. But it tends to be tiny, and it tends to shift with depending on who's in the presidency, which team holds the presidency. I wanted to add a little bit to what Hina said. While much of the problem that we have, I think, is as much a result of congressional abdication and acquiescence as it is of executive branch power grabs. It's always been that way. We do have the additional problem that the Constitution in practice has sort of been turned structurally upside down from what you would learn in junior high civics course in all of these areas, in national emergencies and war powers and in trade. The executive is the first mover, and at least since INS versus Chadha, the Congress in many cases seems to need a veto-proof majority, muster a veto-proof majority in order to rescind action that the executive has taken. And a perfect example of that is the attempt to repeal the national emergency declaration over the border wall. I think you got 12 Republicans, 14, somewhere around there, votes in the Senate. You got a majority for it, but you need, well, we're seeing in how hard it is to get a supermajority in the Senate this week. So I think that's a difficult problem. The other issue was secrecy and war powers. I think a bad situation getting worse. I mean, the most recent example that comes up, I believe the war powers notification for the Soleimani strike was still classified, which includes the legal theory behind to justify the Soleimani strike. So what we have in public, it's very odd because they made a case before. This is the so-called America First president, and he made a public case, legal case in terms of international law before the UN. As far as the domestic law authority for that action, it's still classified. All we really have is some vague gesticulation by the National Security Advisor toward the 2002 AUMF and Article 2 authorities. But that too, in some ways, is nothing new. We had under the Obama administration some OLC memos, even the just dealing with the legal theories of things like the targeted killing of al-Awlaki hidden behind a veil of secrecy.
I'd just like to say something about the secrecy and then bring it back to your question about the informal, the critical informal legislative means of checking the executive. So as Hina knows, my view is that there were many people in the Obama administration, and I think the president was among them, who were in some respects very grateful for the litigation that Hina brought in many of these cases to open up these things, because the president was quite open about wanting to be much more forthcoming, as finally at the end of the administration, you sort of had an 8-year process of laying all that out. And she's right that if it's only at the whim of the executive, the next administration can just get rid of it as they did. But I think much of that was very valuable. But the president and John Brennan and others of us also expressed a lot of frustration because although some of that should and can be made public, in this day and age, a lot of the questions of the use of force and of actions against non-state actors in particular, you run into secrecy problems because of sources and methods and because of diplomatic arrangements, agreements that have been made with other countries regarding consent and an agreement not to talk about the fact that you've engaged in those discussions. And these are real problems, not just for the United States, but for all states, to be able to be forthcoming about their intelligence and their justifications for what they've done and for what the relationships are between a host country, for instance, and an acting country. And I couldn't, and I couldn't help but notice, for instance, you mentioned the U.S.'s Article 51 notice the Security Council about Soleimani, tells a very broad story about Soleimani and Iran was responsible for a series of attacks against U.S. bases and U.S. persons that was only increasing, it was continuing, and there were plans for further things, and Iran was responsible. And really, if you believe all the facts in there, I think there's actually not a bad legal case for the ability to use force, although I think it was, as a policy matter, a very bad idea. And Iran, 3 days ago, wrote back to the UN Security Council and basically said, none of those facts are true. We weren't responsible for any of these attacks, and we weren't planning more attacks, and neither side provided any evidence whatsoever. How is the Security Council to know what the facts are? And the truth is that both parties, both states, the facts are not something you could lay out on the public record because they're all based on sources and methods and diplomacy that can't be disclosed. And that takes me back to Congress, right? The way the system is supposed to work, and that it used to work, as my understanding is, you had to make your case to your oversight committees and the intel committees, and they were pretty strict about holding you and making you show the evidence and making your case. It was so striking that I think it was Rex Lee that came out of that brief, not Rex Lee, Mike Lee, that came out, sorry, Rex is his father, came out of that briefing saying that was the most pathetic briefing I've ever seen. They made all sorts of claims, had nothing to back it up with. Now, I'm not saying whether the intelligence supports it or not. I haven't the foggiest idea. That's part of the point. But then they didn't do anything about that, right? They didn't put the executive branch to any burden of coming forward with better intelligence to make the case for why this was a good, let alone legal, operation. And that check, which was the only check that was around and a very effective one for a long time, That's what I really fear is being diluted
So,
significantly.
yeah, and look, I'm going to take issue with some of the, I actually think the executive branch has, even in the Obama administration, leaned too far into some of those arguments about sources and methods protection. Because one of the challenges, and I served on the Intelligence Committee, is that they seem to think, administrations seem to think that you can protect the information indefinitely and that it's never coming out there and that they should be believed because of sources and methods. And I get that there are sensitivities about the relationships with other countries and who provides us with what, but I gotta say the secrecy, at least in the many of the briefings that I received, inhibited a conversation about really what was going on, and members of Congress often are not competent to really challenge the intelligence that's provided to them. And so I have been called in to brief members of Congress in advance of intelligence briefings from the executive on multiple occasions to help them prepare for this moment when I can't go into the room with them, right? And the thing that I always tell them is challenge the basis of the knowledge. And I got to tell you, as some
Challenge the exclusion of staff.
and challenge the, I mean, I have a whole thing about challenging the
that's
exclusion.
really important.
I agree. And like, look, I personally felt like in the Bush administration, the failure to allow members of Congress to have even communications with their staff, even when staff wasn't allowed in the room on certain rendition, interrogation, and detention programs, was actually unconstitutional. That as a matter of the Constitution, the staff and the member are a constitutional unity, and the executive branch cannot tell a member of Congress who they can share with on their staff, that they are one. And so in the sense that the president can choose who they talk to in the executive branch, a member of Congress should be able to choose who they talk to, and if they want advice of counsel, they should be able to get it. But on the Soleimani piece of it, like, look, I was on the Hill when we received a number of briefings about Iranian responsibility for attacks against U.S. service members in the 2003 to 2007 timeframe. And I have to say, much of the evidence which we received in classified briefing, which later appeared within days in the New York Times, was a circumstantial case. That the levels of responsibility and control that you would want to be able to attribute to a state actor were pretty weak. There was a lot of, they use these tactics and therefore, and these tactics are now appearing, therefore they transfer. And that's not to absolve Iran from responsibility, because I do think that they are a nation that uses proxy forces to harm American service members and all kinds of people in the region. And yes, that they are problematic actors, but that is not to say that the administration actually was able to prove their case. And it does feel like, especially with the amount of weakness that we have in cybersecurity, the number of breaches that we have had, that the administration's stance on secrecy and classification over the long run will not be able to stand and poses a much greater challenge to the credibility of the United States government in the actions that it takes and the basis for those actions over the long run than we could possibly even begin to imagine now. Like, we spend a lot of time talking about quantum computing and quantum decryption. Like, there will come a moment where things are going to get out there. And I don't think as the United States government, especially in the national security arena, we are prepared for that moment. I'm sorry, I'm like...
I would just add for the students in the room, this is not just a matter of making the case to your congressional overseers, which I agree is very important in the staff. But within the executive branch, this is the hardest thing about being a national security lawyer, is knowing how hard to push back on and question the intelligence that you're getting from your clients. And Secretary Johnson knows this very well. You struggle with this daily. You can't just take their conclusions. Iran is responsible. Oh, okay. On the assumption that Iran's responsible, you can do the following. But at the same time, the lawyers are not going to be questioning the translations from Urdu from an electronic source, right? Somewhere in between, and this is good lawyering in any context, if you're a criminal defense lawyer, trying to push your client. What is the evidence? Don't take what they say at face value, but ask them to really think through, almost like you would if you were preparing for cross-examination. Really, you say it's that, but if you were, what about this? And pushing for better evidence, it was really quite amazing to me. Sometimes the case was stronger than they suggested. Some of the Guantanamo cases turned out that the evidence that was sitting around that no one was paying attention to was much stronger than what the Bush administration had been invoking. Other times it was their conclusions weren't backed by any evidence at all. And figuring out as a lawyer how to push your client and how far to push your client in terms of providing you the granular details that lie beneath their conclusions just takes good judgment and a lot of hard work and
Yeah.
it's difficult. It's really difficult.
I really want to emphasize that because I think it's important to be relentless about that, because I would say that counsel's failure to push through to clarity about what was actually happening matters not only in a counterterrorism case, but also in the surveillance context, right? Just technical descriptions of certain surveillance programs given to lawyers were then made as representations to the FISA court turned out to be inaccurate, leading to questions about the legal footing of the programs in their entirety. And we've seen this happen on multiple occasions. Like, as lawyers, you may not think you're a technical person, but like pushing through to what's actually happening and how things work, and making sure that those representations are accurate as you take them forward to the interagency process, to the court, to your congressional overseers. Like, those things have huge implications for whether or not something is going to be later found legal or not. I think we wanted to move. Sorry.
Did you want to go to questions?
I did. I feel like we've raised a lot of things, and I'm particularly excited because, like, I tend to watch panels. Like, I watch hockey, which is for the fights. So, like, I encourage you guys. I would like to go to audience questions. I think we have a very feisty group of people up here.
Who's the enforcer here then? The hockey fight. Come on.
I mean, I have to be the moderator. So.
You're the referee.
We have mics coming around.
This is actually a question for you as moderator,
Yeah.
but you mentioned that in the long run, these things will come out. But there was just recently an op-ed in the Post or the Times, I forget which, on the National Archives and the extent to which records are disappearing or rapidly disappearing, and that there may be no long-term historical accounting. Did you see that, or do you have a
I
comment?
did not see that piece. I do think that, like, in terms of records, like, there are huge problems because we have seen in various ways as communication among the government moves off of sort of official interoffice memoranda and to informal ways in which people communicate, email, WhatsApp, that huge parts of government deliberation may go missing. And the government's choice to actually comply with things that are records is really important. And I do think that we are heading towards a crisis. That said, a lot of the electronic information leaves tremendous footprints over time. So I don't know how much is actually lost, but I think it is a concern, especially as we see this administration moving off of sort of official records and into other areas. We saw this in the sort of WhatsApp text messages released as part of the House record on impeachment.
To speak briefly to that point from the immigration perspective, you are seeing sort of a disappearance of information in the immigration context. It seems for two reasons. One, immigration agencies no longer want to be as transparent and forthcoming about their processes to the public. And so whereas before you would see things like asylum officer trainings and various information about process online, you don't find that anymore. It's difficult to access. Scholars or policymakers would in the past have been able to call up some of these agencies and ask questions informally. They're not as forthcoming in that way. You see the agencies that are more interested in the humanitarian goals of immigration perhaps are more forthcoming, but certainly ICE and CBP and others, they never had great procedures anyway, but now they won't tell you anything about what they're doing. So that's one sort of piece of it. The other, I think, which is related, is the push to conceal information to sort of obscure accountability. So there are reports which have been coming out since the middle of last year about abuse of children in Health and Human Services custody and so on. And a lot of this information is sort of going away. It's not clear where it's going, but it's no longer something either that can be, a light can't be shown on it in litigation, nor does the administration have any accountability or any responsibility to sort of follow up on these accounts because that information is no longer there. And so that's some interesting trends you're seeing in the immigration context in regards to information.
Just very quickly in response to your question, I saw that op-ed and it's hugely concerning. We all focus, or at least we in civil society focus tremendously on external mechanisms, right? It is great, and I say this to my students as well, which is it's great if you go into the executive branch or in Congress, because my mentor in law school taught me, you know, and this was in the context of a death penalty clinic, and he said, you all want to become defense lawyers, let me press you to become ethical prosecutors, because one good ethical prosecutor can alleviate the need for 10 defense lawyers to clear things up. And that's something I share with my students as well. Still, there is no replacement for external oversight and accountability. And part of what we're talking about with respect to the National Archives, and also I think on this panel, is it's not enough for the executive branch to police itself and trust us. It's not enough for Congress and congressional staff to be so constrained that they are unable to do their job. It's not enough that courts are now so deferential in the context of secrecy and war powers and emergency powers, because the two things that I think of as hallmarks of sort of our work in this area, transparency and accountability, we don't have a very good record in this country of accountability for executive branch wrongs, especially in the last 20 years in the national security context. At least we had some measure of transparency that we were able to force through. And we're seeing some of those mechanisms break down as well. And to my mind, transparency is not just a good in and of itself, it's because it allows us to engage as a public, as the citizenry, to be more informed. And this is but the latest in a trend of ways that prevent us from being able to engage on terms that are truly authentic as citizenry. And to bring up another point, it feeds into this thing that we're also all struggling with, which is what is information we can rely on, right? And what is information that we can't rely on? And if you can't rely on records being maintained by the government that you can then return and turn to in order to seek accountability, you're losing something very, very fundamental in a democracy.
We have some other questions from the audience.
Yes, pardon me. So I would just like anyone to address, perhaps Marty in particular, it's with respect to the wall and letting the administration go forward with the wall when Congress clearly didn't want it to. It was my impression that the Supreme Court's overruling whichever circuit had stayed the building of the wall pending the litigation was an absolutely critical step here, and something that could have gone the other way. And so so it just seemed to me that the 5 conservative justices chose to greenlight the wall on Trump's behalf. And I don't know whether that's a fair reading of the situation or not.
I hope not. So I think that if the courts ever get to the merits of the statutory questions in the wall, I think the majority of the Supreme Court would overwhelmingly rule against the Trump administration. I think what's going on in that case, and Hina is very aware of this and she's involved in the litigation, is it's one of many cases up there now in which there's a majority of the court that are trying to push back on the types of plaintiffs that ought to be able to sue. And they see the Sierra Club and they're like, it's not your ox that's being gored. This is inappropriate for these sorts of public entities to be doing it. It's not an Article 3 standing question. They're trying to revive a notion of sort of a zone of interest test, taking the statute that the government is using as a defense and saying, what's the zone of interest, who is supposed to be protected by that? And I think it's more of a distaste on the part of a majority of the justices with respect to certain kinds of litigation and certain kinds of litigants, which is predominantly what the Ninth Circuit litigation that Hina mentioned has been focused on. Is this the right plaintiff rather than someone who's not? Maybe I'm being a little too hopeful, but I don't think it's that there's 5 justices who think the substantive legal arguments are good ones. But my point was that it's very depressing that at the final moment when Congress could have made good on its threat to get rid of the transfer power, you know, they blinked and they said, we're going to let you keep doing what you're doing.
Yeah, so just to add on that, the lifting of the stay was with respect to a procedural aspect, that it wasn't with respect to the Ninth Circuit's decision on the merits, which we're still awaiting, which would then go up. You know, I've talked a lot, but I do think that our clients, both the Sierra Club and the Southern Border Communities Coalition, have demonstrated in the ways that you absolutely can in the context of environmental consequences and litigation, as well as harm to communities, why it is that they have standing and why it is that they would have standing to challenge what's partially at stake here, which is violations of the appropriations clause that then have a direct and harmful impact on environment as well as the communities on the border.
We have some other questions in the audience?
Well, thanks a lot for the discussion. It's been great. I would love to have you all speak a bit more to the judicial role on these questions, where you have interbranch congressional and executive disagreement about oversight, subpoenas, secrecy, national security. It seems to me that there's a kind of natural impulse that, well, if Congress seems to be weakly defending its prerogatives, what we should do is sort of enhance the judicial role. But I wonder if that possibly both kind of lets Congress off the hook in a way we should be concerned about, or also implicates a kind of traditional concern that courts getting involved in these disputes risks damaging their own authority and legitimacy in the long run because they're so political. And so I just loved your thoughts about how courts should think about these questions in this environment.
Zach, that actually ties into the last question, because one of the excuses given by the negotiators in Congress who didn't limit the transfer power in this latest appropriations bill was, oh, don't worry, it's in litigation, we'll let the courts work it out. In the meantime, the courts are imposing all these justiciability constraints to not get to the merits, and so Congress sort of kicked it to the courts, and the court might kick it back to Congress, and you're getting in this infernal loop.
Having now spent a significant part of my life litigating these kinds of cases in courts, you know, the backdrop, and Marty's exactly right, the dynamic is like this, you know, turn to that guy. But there is another thread to this, which is really judicial abdication in this context as well, from the judiciary's role to say what the law is, and also to provide a level of remedy and accountability when individual rights are violated. That has happened. Marty's right, as he's pointing out, the ways in which these things have been limited include standing, and it includes things like the virtual evisceration so far of a Bivens remedy to seek damages. It also includes really expansive notions of what could constitute a political question, although there's been some recent pushback against that in the lower courts a little bit, which is not to say that, you know, these cases aren't being brought and we'll be bringing them, and so will many others. It is to say that I don't think the courts are a reliable check at this point, and that Congress cannot absolve itself of the need to act, especially given the jurisdictional, justiciability, and prudential interpretations that are coming from the courts about why they are abstaining, which will continue to urge them not to, but I don't think that we can guarantee it.
You know, in the immigration context, it's an interesting question. I think traditionally, immigration, like matters of national security, constitute a plenary power, and so are shared by the political branches. And the thinking would be that the courts are sort of hands off. And in a way, they have been, to the extent that they have sought to limit, for instance, the president's power. They've done so from the perspective of administrative law, as opposed to making sort of broader proclamations on the president's immigration powers. And so DACA, for instance, was, failed in the courts because it didn't follow the proper notice and comment process for a policy of this magnitude. The one sort of difference is the interpretation of the travel ban, which seems like the courts providing sort of a go-ahead for a broader sense of presidential power in the immigration context, not just as a statutory, but perhaps even as a constitutional matter. But we have yet to sort of see how this is going to be resolved. And so, to the extent the court is involved in managing separation of powers dynamics, it's more been focused on finding the proper boundaries to presidential power as opposed to maintaining, a proper sort of give and take between Congress and the president.
One quick follow-up on the travel ban decision. I wrote after it was decided that the court, contrary to what most people believe, did not say that it was constitutional. In fact, the chief wrote an opinion that virtually came right up to the line of saying President Trump has deviated from the great traditions of presidents going back to Washington and is acting according to impermissible purposes in singling out Muslims. And Justice Kennedy's fifth vote virtually came out and said that and begged President Trump to do the right thing. The court deferred because it thought the court has to be deferential to what the president says his reasons are in certain contexts. And what's missing there, the president, of course, said, I've been vindicated. The court said what I did was legal. Didn't say that what he did was legal. It said that what he did was not reviewable by the courts. But that means if there are people within the executive branch or the legislature who know that this is not predicated upon a legitimate evidentiary case, but is instead being done for unconstitutional reasons, for instance, it's their responsibility if the courts aren't going to step in to say no, which is effectively how I think of what Sally Yates did in her 1 week as acting attorney general. At the beginning of the administration, she said, yeah, as a legal matter, OLC's right. You can, you can tell a story about how this is legal, but I know what's going on, and I'm not going to defend this because I kind of have been privy to what the president's really up to here. She didn't say it in so many words, expecting to be removed, and she was the next day. But that kind of resistance among lawyers in the executive branch and in Congress, if the court's going to be deferential, it falls to lawyers and fine public servants with a conscience to at least say, even on penalty of removal, look, we may get away with this, but there's no legal predicate for it, and you shouldn't do it.
Isn't it a de facto commentary on the Constitution, though, to say that we are fairly certain that this is impermissible and unconstitutional in these various ways, and yet we will accept this as an exercise of the president's plenary power? It's a limitation on the sort of the extent to which the court is willing to take the president to task for doing unconstitutional things because of deference to the president.
Yeah, well, that's the glass 90% empty view, which might be right, but I'm just trying to suggest that don't forget about the other 10%, which is the court's not the only actor that can keep the government in check and complying with the law, and people don't appreciate how much lawyers and other public officials do have the power when the system is working as it ought to put internal checks on what goes on, particularly where the court is deferring and will not reach the merits of something. That is not a green light to do whatever you want. And increasingly, I think, there's a cynicism in which people treat that as such within both of the political branches. And I think that's deeply unfortunate.
I can very quickly.
Please.
Sometimes when I come out of conversations with Marty, I immediately want to go and run and file more lawsuits.
With me as co-counsel.
Yes, look, Marty, we can talk about that. I just want to, we're running out of time, and I want to talk about how we might flip some of this, right? Especially when we're talking about war powers and emergency powers, because the current statutory framework essentially has the executive branch continuing to act unless Congress says no. And it seems like one way to actually have Congress reassert its powers in the way that the Constitution intended is to flip that switch, to have a regime with respect to war powers and emergency powers in which Congress can say, okay, we recognize that you have a level of discretion to act when an emergency is real. Time is not there for you to come to Congress. There's an exigency that is concrete and specific. You can do that, but it has to stop unless we allow it to go forward, right? Which is the flip of what we have, in which the default is continuation of executive branch expansive claims, and instead it would be, you can do it, but you have to have a limit on it so that the public can engage through its representatives and so Congress can actually act.
So we're at time, but since we started a little bit late, I will take a prerogative as somebody who's worked for Congress to suggest that as the political branch, and we've talked a lot about remedies that could be imposed or could be enforced at the courts and things like that, but Congress is the political branch. And I think one of the real challenges that we face in having the political branch assert itself, especially in the national security arena, is that largely the American people don't care and they are not invested in this conversation. 0.5% of the American people serve in the military, and they are concentrated in a small number of states. We haven't had a draft where everyone is at stake since 1973. That is an entire lifetime. And as Congress has given up its powers as bases have closed, as they've gotten rid of earmarks, the members of Congress themselves have no longer had as much of a stake in the outcome of national security as they used to. So their surrender to the executive is coincided with a time where their incentives, their political pressure, and their political tools have all diminished. And we may think that earmarks are dirty and political and not something that we want to do, but they gave Congress skin in the game in a lot of these areas. I did $250 million worth of earmarks for Senator Kennedy every year when I was there, but it gave him a stake in the national security conversation in a very different way than if he hadn't had any of that. But when you start engaging the American people in this, when you think about that, we're all lawyers, and so we focus on the laws and the judicial branch, but I would urge people to start thinking about Congress's incentives. I know that we have a panel coming up later to talk about that, about why it is that they have actually surrendered and what would need to happen to reinforce the sense that they have an independent political basis for action other than that of the president. But before we get to that panel, I know that we have a lunchtime speaker here who has been very involved in national security. So I would like to thank the American Constitution Society and our panelists and the audience for all of their participation. So thank you. Yeah.
Good afternoon. I'm Deborah Perlin. I'm the Director of Policy and Program here at the American Constitution Society, and I hope everyone has had a chance to grab some lunch. I know we've had a jam-packed day so far, but our next speaker is sure to keep everyone's attention. Best known for his tenure as Secretary of Homeland Security under President Barack Obama, Secretary Jeh Johnson is a respected public servant who has dedicated his career to public service. As the public face of the U.S. government's Homeland Security mission, Secretary Johnson led the third largest cabinet agency, where his responsibilities span from counterterrorism and cybersecurity to immigration and the detention and prevention of nuclear, chemical, and biological threats. Prior to serving as Secretary of Homeland Security, Secretary Johnson was General Counsel to the Department of Defense, where he was the primary legal architect for the military's counterterrorism missions in the Obama administration, and co-authored the 2010 report that paved the way for the repeal of the Don't Ask, Don't Tell law by Congress. Today, Secretary Johnson is a partner at Paul Weiss, where he advises clients on the legal aspects of cybersecurity, national security, and data privacy, among other issues. A regular commentator on national security issues, Secretary Johnson has testified before Congress on over 30 occasions and has had his writings published in the Washington Post, the Wall Street Journal, and The Hill, among others. Once described by a former Secretary of Defense, Robert Gates, as the finest lawyer I have ever worked with in government, We are so glad that Secretary Johnson agreed to be with us today to share his thoughts on executive power, congressional power, and where the balance between the two should exist. Please join me in welcoming the finest lawyer to have worked in government, Secretary Johnson.
Thank you very much. It's very nice to see so many old friends here who are not so old, but they're old friends, including Colonel Tia Johnson, my former military aide when I was General Counsel of DOD, and the former Assistant Secretary of DHS for Legislative Affairs, who is now on the faculty, Mary DeRosa, Marty Lederman. Where's Marty? There he is, back there, getting food. It's nice to see you. So I served as Secretary of Homeland Security for 1,124 days. I had an app on my phone that was counting down the days, hours, minutes until January 20, 2017 at noon, when I, along with the rest of President Obama's cabinet, would leave office. And for the last year or so, as I would look at that countdown app, I had a fantasy about exactly what I was going to do at noon on January 20, 2017. At that moment, I was going to be at my desk. I would watch the new president on television take the oath of office, no matter who he or she was. And I was going to, at that moment, push back from my desk, walk out the door, wave goodbye to my Secret Service detail, get into my own car, and drive up I-95 in the New Jersey Turnpike to our permanent home in Montclair, New Jersey, and wake up the next morning a normal person. Didn't happen that way. For the second time, I got the short straw, and I was asked to be the designated survivor. First time was 4 years ago for the State of the Union in 2016. For anybody here who doesn't know what the designated survivor is, you can't have every person in the presidential line of succession all in one place at one time. So somebody has to absent themselves to an undisclosed location. And that was me. For the State of the Union 2016, I was disappointed because it's fun to be on the House floor for the State of the Union. You get to wave to mom on C-SPAN and everything. And so I did that the first time I went to the undisclosed location, and then I got the tap on the shoulder the second time for Inauguration Day. And on Inauguration Day, it is fundamentally different because the entire cabinet, most of the presidential line of succession is resigning, except one member of the outgoing cabinet has to remain in office as the designated survivor. So that was me. This time I can tell you my undisclosed location was my house in Montclair, New Jersey. I just went home a day early. And I had to stay on for 7 hours and 32 minutes into the Trump administration as the Secretary of Homeland Security. So when I got asked, I said to Tom Bossert, make sure your boss knows he's effectively hiring me to be the entirety of his cabinet for 7.5 hours. And so I make a great trivia question. I have been a great trivia question. Who was Donald Trump's first Secretary of Homeland Security? That's me. Who was the first one to resign from his administration? That's me. And of course, being part of his administration, I faced the scorn and ridicule of many people, and including law professors, various law professors who have said to me, why didn't you invoke the 25th Amendment when you had the chance? Anyway, I'm happy to be part of this symposium. I'm a big fan of ACS. I have attended many ACS conferences in the past, and the subject matter, unilateralist presidencies and submissive legislatures, is of great personal interest to me. When I was invited here 2 months ago by email received at exactly 4 p.m. on December 16th, 2019, I accepted at exactly 4:11 that same day and began an outline of these remarks almost immediately. I was prepared to talk about unilateralist presidencies, and submissive legislatures through multiple administrations, Republican and Democrat, to include the events of 9/11, the Iraq War, recess appointments, Libya, Syria, immigration reform by executive action, and funding a border wall by executive action. Then, as is so often the case in the Trump era, there was an intervening event, the drone strike on General Soleimani on January 3, to vividly illustrate the point, and the discussion of war powers, which generally occurs only among national security lawyers and professors, the people in this room, Lawfare and Charlie Savage, and a small number of members of Congress, too small, was thrust back onto the front pages. So today, my remarks will focus on war powers, specifically the President's ability to commit the U.S. Armed Forces into some level of hostilities without congressional authorization. War powers, the intended executive-legislative balance is, in a word, broken. There is no other way to say it. The current scope of the executive's authority in this space is indeed the product of decades of unilateralist presidencies and submissive legislatures. Essentially, Congress has abandoned this space, and the executive, in the name of national security, real or perceived, has filled it, as the founding fathers envisioned it in the Constitution. Congress declares war, and the President, as Commander-in-Chief, conducts it. Congress declared the War of 1812. Congress declared the Mexican-American War in 1846. Congress declared the Spanish-American War in 1898. Congress declared World War I in 1917 and war against Japan, Germany, and Italy in 1941. In recent years, Congress has continued to exercise this responsibility, though in more amorphous terms. The 1964 Gulf of Tonkin Resolution, which was later invoked by the President as the legal justification for the entire Vietnam War, and the various, quote, authorizations for the use of military force, end quote, in 1991, 2001, and 2002. Then things changed. Though the world continues to be a dangerous place, 2002 was the last time Congress stepped up to explicitly authorize kinetic military force. What happened? Again, the answer can probably be reduced to one word: politics. Following the 2002 Iraq War, both members of Congress, particularly those running for president, realized that a vote to authorize war can be hazardous and even fatal to one's political health. The 2008 Democratic presidential primary turned in very large part on the fact that Hillary Clinton voted to authorize the Iraq War and Barack Obama was on record against it. Collectively, members of Congress no longer want to take a hard vote on whether to go to war if they can avoid it. This is not for lack of asking by the executive branch. In 2013, the Obama administration asked for congressional authorization to strike chemical weapons facilities in Syria. Congress did not act on this request. In 2015, the Obama administration asked for congressional authorization to use military force against ISIS. Congress did not act on this request. The notion that Congress declares war and the President conducts it has never been black and white. As reflected in Madison's notes of the original Constitutional Convention, the framers recognized that in the absence of congressional authorization, the President should have the limited authority to use the armed forces to, quote, repel sudden attacks, end quote. This was conventional wisdom as recently as 2007. In December 2007, Charlie Savage, then of the Boston Globe, now of the New York Times, sent the 2008 presidential candidates a questionnaire asking them to describe their view of the president's war powers. The Obama campaign took Charlie's questionnaire seriously and put considerable time and thought into answering it. Question 2 is still relevant today, 12 years later. In what circumstances, if any, would the president have constitutional authority to bomb Iran without seeking a use of force authorization from Congress? Answer from the Obama campaign. The president does not have the power under the Constitution to unilaterally authorize a military attack in a situation that does not involve stopping an actual or imminent threat to the nation. In retrospect, this answer is wrong. It was far too narrow a construction of the president's constitutional authority, as the Department of Justice Office of Legal Counsel currently describes it, though candidate Obama disclosed in that same questionnaire that he had the supposed legal experts Lawrence Tribe, Cass Sunstein, Greg Craig, and Jay Johnson help him with his homework assignment. Candidate Obama went on to say, in response to question 2, history has shown us time and again, however, that military action is most successful when it is authorized by the legislative branch. It is always preferable to have the informed consent of Congress prior to any military action. And when he became president, Barack Obama did in fact tell his national security team that he strongly preferred military action that had been authorized by Congress. At the time, for us, that meant the 2001 and 2002 AUMFs. And at least during the time I was general counsel of the Department of Defense, the Obama administration construed the 2001 AUMF to provide the domestic legal authority for military force against core al-Qaeda, the Taliban, al-Qaeda in the Arabian Peninsula, and the al-Qaeda elements of al-Shabaab in Africa. Both the Bush and Obama administrations construed the 2002 AUMF to provide the domestic legal authority for armed conflict against Saddam Hussein's regime in Iraq and for military force against armed militia groups that sought to drive U.S. forces out of Iraq after that regime fell. I personally do not believe the 2001 AUMF covers armed conflict against ISIS in Iraq and Syria, or as some have argued, that the 2002 AUMF for Iraq can be stretched to have justified lethal force against the Iranian General Qasem Soleimani. In the meantime, as Congress has not acted in this space for the last 17 and a half years, DOJ's Office of Legal Counsel has had to fill the void to articulate the contours of the president's domestic legal authority to commit the armed forces in specific situations without congressional authorization. Clearly, OLC's recent opinions have described that authority in broad terms, far broader than I anticipated when I helped candidate Obama answer Charlie Savage's questionnaire in 2007. In 2011, on April 1, 2011 to be specific, OLC opined that, quote, the president had the constitutional authority to direct the use of military force in Libya because he could reasonably determine that such use of force was in the national interest. In that case, what was the national interest? There were two cited by OLC. Preserving regional stability. Isn't there always some place in the world where stability needs to be preserved? And supporting the UN Security Council's credibility and effectiveness. The only limitation spelled out in the OLC opinion of 2011 was that the operations must be limited in duration and scope so as not to rise to the level of a full-scale war, which only Congress can declare. This opinion broke new ground. It went far beyond any rationale of self-defense or imminent threat to justify the use of military force without an authorization from Congress. Subsequent opinions of OLC have staked out the same broad authority to address other circumstances. In 2014, OLC issued an opinion that the president had the constitutional authority to launch airstrikes against ISIS because of the, quote, important national interest in doing so, and because the anticipated nature, scope, and duration of the military operations did not rise to the level of a war within the meaning of the Declaration of War clause of the Constitution. In 2018, OLC issued an opinion that the president had the authority to direct airstrikes on Syria's chemical weapons facility for the same reasons. Then came the Soleimani strike last month. As I told Meet the Press, Face the Nation, CNN, and others, if one believes everything the government is saying about General Soleimani under existing OLC opinions I have just recounted here, he was plainly a lawful military objective, and the president had ample constitutional authority to take him out without congressional authorization as a general in a military engaged in hostilities against U.S. armed forces. But in the face of conflicting justifications for the strike, uncertainty about whether the strike was the escalation to a full-scale war with Iran, and a president perceived to be compulsive and erratic in his decision-making, many in Congress want to finally reassert themselves through invocation of the War Powers Resolution. The War Powers Resolution is outdated, plain and simple. Invocation of it now also presents a constitutional conflict between the two political branches of government that has been brewing below the surface for years. As most of you know, the War Powers Resolution was enacted by Congress in 1973 over Richard Nixon's veto as an effort to rein in the president during the Vietnam War. Put simply, it says that if a president initiates hostilities without congressional authorization, he must stop if Congress so directs by concurrent resolution, or within 60 days if Congress has not provided that authorization. 6 days after the Soleimani strike, the House passed Concurrent Resolution 83, offered by Congresswoman Alyssa Slotkin. The resolution invokes Section 5C of the War Powers Resolution and purports to require the president to terminate the use of U.S. armed forces to engage in hostilities in or against Iran, unless authorized by Congress. This resolution has virtually no chance of legally binding the president's actions, as the concurrent resolution is not submitted to the president for signature or veto. Further, the Supreme Court's 1983 decision in INS v. Chadha, as you heard in the last panel, makes clear that Congress itself cannot veto executive action simply by concurrent resolution. Likewise, Senator Tim Kaine has offered a joint resolution in the Senate that invokes the War Powers Resolution and that directs the president to remove U.S. armed forces from hostilities against Iran. While a joint resolution passed by Congress is traditionally submitted to the president like a bill, even if this one passed both houses of Congress, it would almost certainly be vetoed by the president, and there will not be enough votes in Congress to override it. More fundamentally, the wording of both resolutions purports to limit the president's authority to use the armed forces without congressional authorization to just defending the U.S. against imminent attack. Meanwhile, as I've detailed earlier, OLC says the president's constitutional authority to use the armed forces without congressional authorization is far broader. This is the constitutional conflict. Don't look to the courts to resolve such a conflict. The courts will decline to get into the middle of such a constitutional dispute between the two political branches of government, either because of lack of standing by a plaintiff to bring such a lawsuit, or because the lawsuit presents the quintessential political question that courts decline to resolve. The War Powers Resolution, in my judgment, should be repealed and replaced, to use a well-worn phrase. I support the proposed War Powers Consultation Act offered by Senators McCain, Kaine, and King in 2014. This bill strikes all the right balances. It repeals the War Powers Resolution, it preserves the president's constitutional war powers, puts the onus on Congress to act, and does not outright require the president to withdraw forces in the face of congressional inaction. This bill has been sitting in Congress for 6 years. I wish more in Congress would have an abiding interest in this important subject, and not just for a few weeks after a drone strike. After all, it's nothing less than the Constitution and matters of life and death. In closing, I wish to make several discrete points. First, this discussion has been all about domestic legal authority to engage in armed conflict. Nothing here reflects the international law and what it permits or provides. Second, I have done my best here to convey the current view of what the president's war powers are, not what I believe they ought to be, particularly in the realm of constitutional law. Too many commentators tell us their personal preferences for what the law should be, masquerading as what the law is. Third, and related, just because I tell you there is legal authority to do something doesn't make it a good idea. During my days at the Pentagon, I signed off on a number of things by saying legally available but politically stupid. Finally, as we discuss presidential war powers here at the Georgetown Law Center in Washington, let's never forget the bravery and dedication of those on the front lines who must act on a president's war powers and Congress's authorizations. In these remarks, I have made reference to the 2001 AUMF as if it were a sterile legal acronym. But as of today, 2,445 members of the U.S. Armed Forces have given their lives in Afghanistan pursuant to it. Today, thousands more are forward positioned in places like Iraq, Afghanistan, Syria, and the Persian Gulf, ready to risk their lives on a moment's notice to carry out the orders of our nation's civilian leaders. It's time for our leaders to exercise some political courage and resume the responsibility to stand up and be counted, yes or no, on matters of war and peace. Don't they owe this to our nation's military, whom we count on to exercise real courage in defense of all the rest of us? Thank you. I think I have time for questions. I think I have 15 minutes. Who would like to ask a question? In the Coast Guard, there's a rule. No, you can't leave the meeting until 2 people ask questions. Yes, sir.
Okay, this might be a dumb question, but here goes anyway. The strike on Soleimani. He's in the battlefield. Doesn't that make him a legitimate target? I mean, hey, if you went out there and they shot you, I would say, hey, life in the big city. Deal with it. Am I wrong, or I'm just on it? I think I've said enough.
So you're asking whether he's a lawful military objective?
Yes, because he's in the battlefield.
He was a 3-star general in a nation-state's military force that for years had been engaged in armed attacks against U.S. forces in Iraq and elsewhere. And therefore, under existing Office of Legal Counsel opinions, which are public, set forth in writing, he was well within what we would consider to be a lawful military objective, and the president had constitutional authority to take him out. Many people don't like that, particularly if it's escalating toward a full-blown war, which only Congress can declare. But under existing judgments about the president's legal authority, he was a lawful military objective. And in general, a general in an armed force of a nation state engaged in hostilities against our military is a lawful military objective. I would differ with whether a general counsel is, a civilian general counsel, but that's, conventional law of armed conflict wisdom.
Hi.
Yes.
Hi. Mika Oyang. I moderated the last panel. I had a question actually about the Obama administration's attempt to seek authorization for use of military force in Syria, which was an attempt that they made but didn't ultimately exercise. And given the strikes that were contemplated at that point.
Didn't exercise or didn't get Congress to act on?
Well, it did not. Congress did not complete its action, and the Obama administration, as I recall, did not actually take the contemplated retaliatory action against the Syrian government in that instance. Given the political consequences.
You're asking about 2013.
Yes, I'm asking about 2013 and the response to the chemical weapons and crossing of the red line. Given that the authority it was a futile exercise of power or Congress never completed its consideration of that, and the Obama administration did not use it, what do you think the long-term implications of that were? And do you think in retrospect, the Obama administration should have not sought that authority?
Well, my easy out here would be to say I was a private citizen in 2013, but I won't say that. When the Trump administration in 2018 took out the chemical weapons site, Secretary Mattis went out publicly and clearly parroting OLC and what the lawyers told him to say, said it was in our national interest to take out this facility. And national interest is now defined in very, very broad terms. So that was the domestic legal authority for that strike. The international legal authority for that strike, the Trump administration, so far as I know, has yet to publicly explain what that was, because there was no UN Security Council resolution authorizing it. There was obviously no host nation consent, and it was not strictly an act of self-defense. So what the international legal basis for such an action would be is a hard judgment to make. The calculation about whether striking this is a matter of policy, not law. The calculation as to what the reaction would be in Syria, I think has proven to be correct. There was no massive retaliation. It was a very discreet act in response to what they did to their own citizens, and I think it was the right thing to do. Yeah, international law hadn't changed in 5 years, right? So, the international legal basis for taking out a chemical weapons facility of a regime that is being used against their own people is hard. Most nations do not accept, responsibility to protect a people from their own dictator as an acceptable basis for intervening in a sovereign nation. It's an interesting debate to have, but most nations do not accept that as an international legal basis for military force. Yes, sir. Right here.
Thank you. I'm Jack Hinman, the State Department. I have a question that's, I don't know if it's totally legal. Also, I have a confessed to a conflict of interest. My son was on the party plane coming back from Moscow. He and I have both worked with Bill Taylor. And he just got a big promotion that I don't like at all. He's going to be head of peace and stabilization in Kabul, as if there was any peace to stabilize there. And my grandson just came back from the 173rd Airborne. So one comes back out of danger, the other goes right back in. But it sounds like what you were saying, if I got it right, is that it's in the national interest very much for Congress to retake its authority and vote on these and legislate on these things. That there's an individual incentive, a negative incentive for, or at least it can be, did I get it right, for individual senators and congressmen, that they go on record and then they get nailed for it later on. So is that part of why Congress has backed away from its power, or is there a way of restructuring those incentives? I mean,
well, there ought
in their personal interest as well as the national.
What I've tried to say here is that our politics has evolved to a place where Congress collectively doesn't want to have to take any hard votes, especially if it's a matter of war or peace, unless they could somehow know how it's going to come out. And this was a big issue. This has been a big issue in presidential campaigns. So collectively, though they get upset when you don't consult them before or after a strike, and they all complain about it, and they all complain about how we're in the executive branch conducting the war, collectively, the response often is, and Mary knows this, and Marty knows this, collectively the response is often, hey, haven't your lawyers told you have the authority to do this anyway? What do you need me for? What do you need? Don't ask me. That's too hard. And so that's where we have been, in my view, over the last 17 years.
That's what you were saying. Is there any way to restructure that incentive so that what you were saying, I'm sorry for the repetition, but it just sounds like it is not actually in the congressmen's and senators' interest to go on record on this.
The bill that was offered 6 years ago by McCain, Kane, and King removes the presumption that silence is disapproval. And the bill would force a vote within 30 days. You have to stand up and vote up or down. You can't just sit back and fight in committee and nothing ever happens. They have to take a vote one way or another. And I think that's, given how our politics has evolved, I think that's necessary on important constitutional level matters of war and peace. Make these people stand up and be counted. Inaction should be unacceptable. Yes.
Do you think the OLC opinion on the Libya strike was correct as a matter of U.S. constitutional law?
I'm not a constitutional expert. I accept the law as it's given to me by very smart people like Marty Lederman and Caroline Krass. That's a cop-out. It was a very broad opinion, and it went broader than I had anticipated. Marty, what do you have to say about that?
Well, I've written that it is mostly right, but that it was too broad.
He had left OLC by then.
That it was too broad in certain respects, and that in particular, it didn't lay down the lines that are important in some of these cases, including the interaction between international law and the president's constitutional authority. But do you mind if I change the subject a little bit? Just to invoke something I did in the last panel, just because we have Secretary Johnson here, and I've never seen anyone both struggle with this more or deal with it better than he did. And maybe you'd be able to tell the students here something about what we were discussing, which is the difficulty of government lawyers in particular dealing with intelligence that they're getting that is the predicate for all of the legal decisions that we offer, and finding that right balance between accepting the conclusions that the intel services or the military components in the Defense Department, what they tell you, and how far you push back on that and ask them to see their homework, see the evidence, haven't they considered X, Y, and Z, and the like. It's a very hard balance to strike. There's no formula for that sort of thing, especially when everyone's saying to you, hey, you're just a lawyer, accept our facts as a given and tell us whether it's legal or not. But I learned from you how to do that, or how to try to do that.
So here's how it works, or at least it used to work in the Pentagon. Before the Secretary of Defense and the President approved a Title X U.S. military counterterrorism operation, i.e. a drone strike, I'd have to give the legal sign-off. And the special ops people in the chain of command all knew that the lawyer was the most significant stop on the train. And so there's a little office in the basement of the Pentagon called DDSO, Deputy Directorate for Special Ops. And somebody from J3, which is operations, and J2, which is intelligence, and they're part of the joint staff bureaucracy, would come and brief me on all of the intelligence that supported a strike against a particular individual. And we would sit there at my conference table and we would go through it in a lot of detail, because very often what was on the baseball card was rather conclusory. It was thinly supported. And I'd want to see the support for an assertion made that Objective XYZ is a member of AQAP and is plotting dangerous attacks against the U.S. Okay, well, what's your support for that? What does that mean? And they'd have to bring sometimes the raw intelligence, and we would go over it. And I thought it was a healthy exercise, certainly for me and my lawyers, but it was also a healthy exercise for them to substantiate everything that gets put in these baseball cards up through the chain of command. And so they knew they had to come prepared. And very often, a legal conclusion was driven by the facts. So, and the intel. The facts are 80% of the facts are in classified documents. And so I struggled, as you know, Marty, I struggled with whether al-Shabaab should be considered an associated force with al-Qaeda. For 4 years, I struggled with that question. And sometimes the answer depended upon what month it was, because the intelligence about the connections and the affiliations between al-Shabaab and al-Qaeda often evolved, depending upon who was in, who was out, who left the organization, internal rivalries. And so the intelligence evolved. And so it was a very, very fact-intense legal conclusion based entirely on intel. And so I think one of the very healthy jobs for a national security lawyer who's providing legal advice about lethal force is to really give a hard look at the intel that is being marshaled in support of something and question it, ask to see the underlying support for it. And it's a healthy exercise for everybody. Yes, Colonel Johnson.
Thanks, sir. And what you're really saying in many ways is that you've got to know your client's business. You've
Yes.
got to understand what it is they do, how they do it, and how they arrive at the conclusions that they arrive at. And as you said, you just can't accept it for face value, which means then that you can't do drive-by legal advice, because you're not going to be able to know to ask the right questions if you don't understand how they derived or arrived at the conclusions they're presenting you.
Which is why, as Tia knows, after every airstrike I signed off on, I would watch the video of the airstrike to understand the gravity of what I had given the legal sign off for. And because I learned something new about the techniques and the technology and the operation, I learned something new every time I watched one. And the operators appreciated that. Yes. Yes, ma'am. Yes.
Can you speak a little bit more to the interplay between domestic and international law, and perhaps rely on your colleague in the back here?
Yes. So, as a lawyer in the for somebody in the military chain of command, in my view, you have to ask 3 questions. One is and they're separate. One is their domestic legal authority for the action. Is there international legal authority for the action? And would the action comport with laws of armed conflict? Necessity, proportionality, distinction. International legal authority, domestic legal authority comes from 2 places, either Congress or the Constitution. Is there authority in existing statutes, or is there authority in Article 2? International law, it comes from 3 sources. A UN Security Council resolution authorizing use of force, all necessary measures, quote unquote, or host nation consent, or, and this is the most controversial, and this is the one that was invoked for bin Laden, as an act of self-defense if the host nation is unwilling or unable to deal with the threat itself. And those are the 3 sources of international legal authority for military force. I talked earlier about responsibility to protect, R2P, which many people have argued for. If someone is committing genocide against their own people, don't other member nations of the UN have the responsibility and the authority to intervene? And some nations, some European nations have argued for that as an acceptable international legal basis, but it doesn't have wide-scale acceptance in the international legal community, at least yet. And so that's where we are. But those are two fundamentally different questions: domestic legal authority and international legal authority. That's that's the international law of armed conflict. That always applies to any use of military force, and every JAG or lawyer somewhere in the chain of command in providing a legal advice on use of force has to be mindful, is governed by those principles. Okay, thank you all very, very much.
Good afternoon, everyone. Wait for everyone to get back to their seats. My name is Nick Rawlinson. I'm a 1L representative here at Georgetown ACS chapter. First, I'd like to thank Secretary Johnson for being with us today. He certainly gave us a lot to think about in terms of our core constitutional commitments. Really appreciate his time. It's my great honor to introduce Rita Jo Lewis, who will moderate today's final panel, Imagining a Resurgent Congress. Rita Jo is the Senior Fellow and Director of Congressional Affairs at the German Marshall Fund, where she works to strengthen the next generation of transatlantic leaders, including through its Transatlantic Congressional Staff Salon Series, briefings on Capitol Hill, and engagement with the European parliaments. Previously, Rita Jo served as the first ever special representative for global intergovernmental affairs at the State Department. Prior to joining the Obama administration, Rita Jo worked at the Chamber of Commerce, was of counsel at Edwards Wildman Palmer, and was a 2014 mayoral candidate here in the district. We're so glad she can be with us this afternoon to lead this conversation. And please join me in welcoming and thanking Rita Jo Lewis.
All right, just trying to get my instructions down pat. Well, first of all, I think that the last speaker, our secretary, gave us a great intro into this particular panel. And it's just really exciting to be here with ACS. And we want to thank them for inviting all of us this afternoon to discuss Imagining a Resurgent Congress. So you've had a full day of discussions at a very hot time in Washington. I don't say it's an important time, I say it's a hot time, even though it's cold outside. But I am joined today by some very esteemed, accomplished leaders. You have their bios in in your packets. But we have, let's see, yes, Simon, you're right here on the sheet. Simon Lester, who's our Associate Director and of the Herbert Stifel Center for Trade Policy Studies at Cato Institute. We have Zachary Price, who's a professor of law, who's down on the end at UC Hastings College of Law. We have Kate Shaw next to him as the professor of law and co-director of the Florsheim Center for Constitutional Democracy at Cardozo School of Law. And then finally, we have Donald Sherman, who's the deputy director of Citizens for Responsibility and Ethics in Washington at CRU. So let's first give them a round of applause for just being here today. All right. We want to make this very interactive. We know we're at the end of the day, and we want to encourage our panelists to be able to weave in personal details, whatever about their experiences, not just about the law, but also they have had unique experiences, as you've seen from their bio. And then we want to also make sure we leave some times for some questions from each of you, because we thank you for being here today and here in this audience. You know, when I received an invite from ACS, you know, I had to go back to the Constitution myself. I had to you might not believe this, but as I travel in Europe, I carry this thing around. Because to me, this is the best thing for me to stand on when I'm out there talking to Europeans about America and its government and all the issues that were going on. So we look at this whole question around separation of powers, and we know that's going to be a big topic for this final panel here, especially because of Article 1. That's why we're here this afternoon. So I kind of want to throw out a question to each of the panelists, but this one is going to be for all of them. And we kind of want to look at kind of theory, and I say it's theory and history, versus the real political reality. So we seem to be, there's a theme now in congressional and executive power conversations that in theory, Congress has all of the powers. It's like the trade power, the appropriation power, the oversight power. But then we look at reality about how they're executing those powers. And then we have seen, I think in many instances, successive administrations have begun to argue that these constitutionally sanctioned authorities are in fact unconstitutional infringement on executive authority. So I think for each of you to kind of give your thoughts about what are some of the practical challenges standing in the way of the congressional exercise of its power, and are there similar impediments to all of these powers? So let's start at the end. They told us, pick up the mic.
Well, first of all, let me just echo the thanks to Deborah and ACS for having me. It's been a great event, and I'm honored to be here. I mean, I think on the general question, I mean, it's not a particularly original thought, but I think there are kind of structural institutional disadvantages that Congress has vis-a-vis the president in shaping separation of powers practice. And it's partly that Congress is a multi-member body, so there's a kind of collective action problem in asserting itself, whereas the president as a unitary actor can pretty forcefully defend presidential interests. But it's also the way that a function of the way partisanship interferes with Congress's kind of institutional self-defense, because for individual legislators, there's often a partisan interest related to their, whether the president is part of their party or not, that overrides whatever interest they might have in defending institutional prerogatives. So I think that dynamic explains in large part why practice has tended to move over time in a more pro-presidential direction. I think unfortunately those dynamics are getting worse, because as the country gets more polarized, as the partisanship increases, it just compounds those problems and creates an increasing risk that presidents can take actions and Congress won't push back in a meaningful way.
Yeah. Yeah, so I largely agree with what Zach just said. The kind of founding era vision, right, very much associated with Madison, right, this Madisonian vision of inter-branch rivalry, that Congress and the president are going to have their sort of institutional loyalties first and foremost, and that they will vie for primacy, has obviously been overtaken by several decades worth, I won't say a moment, but sort of a trajectory in which partisan affiliation very much trumps institutional affiliation, so that when one or both houses of Congress have a co-partisan, right, a member of their political party in the White House, the affiliation is to party over institution. And thus, when you ask what are the main impediments to sort of congressional assertion of congressional authority, well, Congress is one of the main impediments to congressional assertion of congressional primacy vis-a-vis the president. So that's one answer, of course, is partisanship in this kind of hyper-partisan moment in which we're living. And there's tons more to say, but maybe I'll just give one specific additional answer, which is there have been a lot of kind of separation of powers disputes play out in ways that don't necessarily ultimately get resolution in the courts. And I think, for law students, it's like the law is what courts say the law is, and that is largely true. But in a lot of these disputes, courts don't get to weigh in at all, right? And so law is kind of these resolutions or agreements reached between the political branches, and that's real harder to get your arms around than it is, to read a judicial opinion. But there are certainly some important judicial opinions that sort of structure this area, and one of them I'll just maybe mention briefly is Inez versus Chadha, and that's an opinion that I think has had real implications for Congress's ability to act in certain ways as a meaningful check on the executive. And so that's, of course, the 1983, I think, Supreme Court opinion in which the Supreme Court strikes down the legislative veto. And the legislative veto was an important, and the opinion, seems right in lots of ways. It's sort of too formalistic, and I don't know if for law students who've read it, sort of if it seemed right or seemed wrong, but it certainly, as a practical matter, has had the effect of, so Congress in the age before Chadha would give these broad delegations to the executive branch, but retained this ability to veto certain exercises of the delegated authority that Congress handed over to the executive. And when that went out the window, but the big broad delegations in statutes remained, it made it a little bit more difficult for Congress to keep one hand in the activities of the executive branch. There's a great line in the Justice White dissent in Chadha, in which he says, without the legislative veto, Congress is faced with a Hobson's choice, either to refrain from delegating necessary authority, leaving itself with the hopeless task of writing laws with the requisite specificity, or in the alternative, to abdicate its lawmaking function to the executive branch and independent agencies. And so that actually is this, Supreme Court opinion that I think, seems kind of discreet, but has had very significant implications in disempowering Congress vis-a-vis the executive.
No, there we go. So first, I want to echo thanks for having us and having crew here. And then I want to echo something that Kate said. As a practitioner of oversight for almost a decade, most of these disputes between the executive branch and the legislative branch don't go to court, are resolved by people engaged in negotiation and accommodation, which is how the courts and have interpreted Congress's authority here. But I think the particular conflicts that have arisen in this administration are unprecedented for many reasons, and it is reinforced for me frankly the cliche that power comes from the people, and institutions are only as strong as the people that support them. And just to give you a couple of examples, we have certainly lamented the president thumbing his nose at congressional authority, and we've watched as the courts weigh these decisions. But ultimately, in a lot of cases, Congress has not gotten the information that they've requested because the president has decided not to cooperate, and the officials in his government have agreed with that. And I think there's been a lot of sort of questioning about whether Congress has the authority or Congress's power has been diminished. And as I prepared to come here, I remembered not that long ago where Congress flexed its authority against a duly elected president, and a fellow named Merrick Garland, who was nominated to the Supreme Court by a president, was denied a hearing, and the president's authority was denied by Congress. And so, the idea that either one of these institutions can engage in conduct, uphold their oaths, is there's obviously the conversation about what the law requires, but ultimately it's what the public will countenance. And I think there's a reason why Senator McConnell felt empowered to do what he did, despite, I think, very strong legal arguments that he was operating outside of his authority. And I think there are strong arguments why President Obama took executive action when Congress wouldn't act, and why President Trump has taken executive action and done other things to thumb congressional authority. And I'll sort of end with a positive note, because I think again, these powers, obviously these powers exist, but they only really work when people because people support them. And I'll point to no clearer example than when the president directed his cabinet officials and his appointees not to cooperate with the impeachment inquiry, and Ambassador Sondland thumbed his nose at the president's authority and went up to Congress and testified under oath, as did Ambassador Yovanovitch. And so, I look at this, there's a valuable conversation that can be had about, how the law interprets the powers that are vested in the executive branch versus the legislative branch. But at the end of the day, a lot of what actually happens in the real world depends on whether people are going to stand up to support the law and support the institutions. And we have some examples of that, despite what has been this administration's obstructive conduct.
I mean, how do you view this?
Well, thank you. Very, very nice to be here. Focusing on trade policy, I think in the trade policy field, we find ourselves with a bit of a dilemma here. We have this instinct, you're seeing how the Trump administration has been acting, that, oh, it'd be nice to give some more power back to Congress, but there's a long history with congressional misuse of its power over trade. So in the 19th century, the early period of the 20th century, Congress was doing a really bad job with trade policy, basically sort of trading off special interest favors. You know, one member of Congress would say, I'll vote for your special interest thing if you vote for mine. And we ended up with a big mess of Smoot-Hawley tariffs. And at that point, Congress delegated a lot of its power to the executive branch. And for the most part, you know, I think that I and people in my field think that was a good thing to do. We're suddenly confronted with a president who's now abusing some of that delegated power. But I think we'd be reluctant to go back to the old way. We don't think that would necessarily be better. In addition to that, the whole practice of trade policy has evolved. So, you know, if you go back to the 19th century, it was just a domestic policy issue of how high tariffs should be. But now trade policy revolves a lot around negotiating with foreign countries. And I have done some speculation as to what would it look like if Congress negotiated with, you know, a foreign country. It doesn't really work. I mean, I tried in my head to make it work, figure out if there's a way to make it work, but it really doesn't. So I think what we have to do in trade policy is think about slightly refining the balance. I mean, I think overall we're happy with the idea of we've delegated some of these congressional powers over regulating commerce and tariffs to the president, and recognizing that the president has power over foreign affairs. So it's just a question of given the changed circumstances of this president and showing how a president might act, how can we refine this balance rather than going back to the way things used to be as they originally were under the Constitution?
You know, in a recent Take Care blog that you did, Zachary, you wrote that arguing that the president cannot constitutionally withhold foreign aid that's mandated by Congress, and that the president and his defenders should not be allowed to make other congressional power collateral damage in this effort to keep president in office. So those other congressional powers you're referring to often includes, all the time, of course, the appropriations power. So with impeachment just behind us, I wonder, is the appropriation power collateral damage to the president's acquittal? And then what other congressional powers like oversight, how do we fare with impeachment now behind us? And so why don't I start with you, Zachary, and then move to Donald, who has that oversight.
Sure. So I do think that Congress's appropriations power is especially significant and often one of its most effective tools. I think it is at some risk. I don't think impeachment should be understood to undermine it totally. But so let me just explain all that. So I think appropriations are particularly, it's always an important congressional power. It goes way back to 17th century England. That is important legislative authority. But I think it has a particular significance now because of a number of the themes that have come up over the course of the day. I mean, at this point in history, the executive branch has a lot of authority, partly through an accretion of statutory delegations, but also through kind of evolved practice over time. And, we might lament that reality. I think in some ways it's a kind of inversion of the original constitutional design, but it's not likely to go away. There are some good reasons why things have developed that way. And so Congress is then often in a reactive role. The president has a lot of power of initiative and setting policy, both domestically and in foreign affairs. And within that context, the appropriations power is really important because it's where Congress gets to kind of push back on the president. Because every year we have this practice of annual appropriations, so the president has to come back hand in hand to get Congress to give more money, and that gives Congress an opportunity to push back. And it does this quite a lot. It often puts in limitations, restrictions on funding that override regulations, prevent their enforcement, adjusts laws kind of as a practical matter in that way, and mandates spending for things the president doesn't want. So it uses it, and it's, for the most part, I think it seems to be one of Congress's more effective tools. There have been political scientists who've looked at this and seen that, to perhaps surprising degree, Congress often seems to get its way when it does things through appropriation. That might just be because of that relationship of dependence. It might be because Congress is particularly attentive to this power, but in any event, that at least has been the general reality, I think. Now, as for impeachment, I think in a way, even the kind of Ukraine episode fits that pattern because, Congress mandated this aid to Ukraine. The president, is at best indifferent to Ukraine. I mean, he tried to impose these conditions on it. That's what he got impeached over. At the end of the day, they got the money without the conditions, without doing the investigation he was trying to get. So obviously it was a pretty ugly process to get there, but it does at least sort of fit that general pattern. And I at least think the acquittal should not be interpreted as, so in the debate, what I was responding to in that blog is, people started coming up with all sorts of arguments for why what the president did was lawful and appropriate. I don't understand the Senate's acquittal to be an endorsement of those theories. To me, it reflects whether you agree with it or not, a political judgment that removal from office wasn't warranted given his conduct. So, I'm on the other hand, of course, the president is likely to feel emboldened. So maybe there's risk in that sense. But to me, I think the more concerning problem is the kind of more general dynamic we've been talking about of the way that people talked about throughout the day. Presidents, get elected expecting to achieve certain goals, and so there's a strong incentive for them to push the envelope with all their powers, and including appropriations. This happened with Obama and the Affordable Care Act. He spent his administration kept certain subsidies going despite Congress's failure to make an annual appropriation, I think, on pretty dubious legal theory. So I think there's an incentive that seems to potentially cut across administrations to push against this congressional authority as well. And I do think that's something we should be concerned about because it's such an important congressional power within this environment.
Don, you've been on oversight. What's your thoughts?
Yeah, so on oversight, obviously, there's a number of cases that are moving their way through the courts that could have a not insignificant impact on at least the law related to congressional prerogatives in oversight. But, as a historical matter and as a legal matter, I think the courts have recognized consistently that Congress's authority is broad. It emanates from their ability to legislate, and that Congress is afforded due deference in their oversight requests, which has allowed for sometimes responsible oversight and sometimes abuse. But I think the negotiation and accommodation process has generally worked well to ensure that Congress, when it oversteps, is not effective in its oversight. I think as a practical matter, I do have some serious concerns, not about impeachment so much as what OLC has done over the last several years, because I think whereas it takes a long time for the courts to make decisions, I think OLC has given a great deal of cover to future presidents, to future administrations, to thumb their nose at Congress. I think what will determine the fate of congressional oversight will be what happens to the next president, how willing Congress is to assert its authority and to frankly shame a president who, I think regardless of whether it's a Republican or a Democrat, is likely to have a substantially lower shame threshold than this president. And so I think that will be the moment where we'll really start to see whether the deference that Congress gets, not just from the courts, but in a practical sense from the executive branch, is still intact or is permanently eroded. And, it will be up to Zachary's point, it will be up to both chambers and all of the members of both chambers to exercise their oversight authority in a judicious way, but also without partisanship, and to really, as Kate was saying, reassert Congress's authority to get information that it needs to legislate and to make sure that the executive branch is functioning effectively.
Kate, you've been interviewed a number of times recently in the past, and now just like daily. And what trend do you see? Is this what trend do you see about collateral damage? What is that going to look like?
So I do worry about sort of thinking about both impeachment and oversight. The treatment of subpoenas, right, to the White House and other executive branch entities, and I think that there will be a lot of kind of in retrospective examination of some of the choices made by the House investigators and then the managers to, at a certain point, sort of decide to respond to executive branch stonewalling by simply drafting an article of impeachment around obstruction of Congress, rather than trying to pursue some kind of judicial resolution. So I have a lot of thoughts about that. I mean, so one, I think there's an argument that the House should have at least taken kind of maybe one or two more passes at seeking some kind of judicial resolution. I mean, I don't think they should have to. I think the arguments made in the Senate that only courts can give the final answer to some of these questions is just kind of wrong, as a matter of sort of, if you have even any kind of departmentalist tendencies where all the branches of government get to and have to participate in deciding what the Constitution means and requires, and not just the courts. It seems it's an odd argument to be making to Congress, that Congress lacks the authority to make these kinds of constitutional judgments, but that only courts have that power. But I think that there may have been some value in some kind of expedited process. And Ned Foley at Ohio State had a couple of good op-eds over the last couple of months, making the, I think, very good point that sometimes courts can act with dispatch, right, in election law disputes and death penalty litigation. Now, obviously, those are spheres in which there are hard deadlines, but that the House should have manufactured a couple of deadlines and basically tried to put the onus on courts to try to rule within those deadlines. We should say that the executive branch has been successful in sort of using that tactic. So think about one of the, so Donald mentioned a few big cases coming down the pike. One of them, of course, is the three cases seeking access to the president's taxes, but via these third parties. But the New York case, which is actually not a congressional case, but a case brought by the Manhattan DA, the administration basically said, you have till Friday to rule, or we're going to seek, we're going to file a cert petition, and the Second Circuit obliged and ruled by Friday. And you could imagine Congress playing the same kind of hardball, although like Dahlia Lithwick and Barry Friedman have an op-ed in Slate a few weeks ago making the point that courts have been far less receptive to Congress's request for expedition than to the executive branches. So that, I think, is a very real phenomenon as well. But there might have been some value in seeking judicial resolution. Of course, that path was not taken. So you do worry, now maybe some of these cases that are still coming down the pike will result in some broad pronouncements of Congress's entitlement to lots of executive branch information. And these negotiations happen in the shadow of what case law exists on these questions. So there could be pro-Congress case law that is kind of in the offing. You worry about an emboldened executive branch, not just in terms of the substantive conduct at issue in the impeachment proceedings, but in terms of the conduct vis-a-vis Congress, that the executive branch will feel at liberty to refuse requests for information and to see its subpoenas defied kind of writ large. And I mean, is Good Government Now is the group, right, Bill? So there's an organization, Good Government Now, that's been sort of pressing this argument for some time that Congress should return to the practice of what's referred to as inherent contempt, that once upon a time when Congress saw its subpoenas defied, rather than either running to court to try to enforce subpoenas or asking an executive branch prosecutor to enforce subpoenas, something that the executive branch will no longer do against another executive branch official, it itself basically convened contempt trials and levied fines directly, including appointing prosecutors inside Congress to enforce its contempt citations, and that's a practice that should be revived, and that there are a couple of members of Congress who are, I think, thinking about doing this. And it does seem like a conversation very much at least worth having, that Congress has ceded all kinds of authority, both to the executive branch and to the courts, and that inherent contempt would be one way to try to claw back some of that ceded authority, at least to consider the possibility.
So, let's kind of go back to the previous panels when they were discussing and focused on national security and foreign affairs. And they were discussing how the growth of the national security state has led to a growth of executive power and a diminishment of civil liberties. So, you know, Simon, you spent a lot on these trade issues. Do you think that trade policy is another subset of this conversation? Do you think that is framing trade as a national security issue, allowing the executive branch to kind of seize more power? I know it's kind of like several questions there, but when we start looking at the UK and the US-UK agreement that is getting ready to happen sooner than later, we hope. You got the EU that says we've got that agreement still hanging out there, and then we've just finished with NAFTA, the new US, Canada, Mexico. So is it time for Congress to claw back some of this power, as Kate was saying?
I definitely think that trade policy is a great example of this. I think there are a number of specific areas of trade policy where we're seeing it. We're seeing it with the export control regime. We're seeing it with screening of foreign investment. But I think I'll focus on this one example, and I think we'll talk about it in a later question as well, is that the use of Section 232, the statute where you can restrict imports in the name of national security. And this was a statute that came about during the Cold War. We're worried about, relations with the Soviet Union. It was, used off and on, mostly related to oil imports, but then fell into disuse in about 2001. The Trump administration came into power and they revived it and they embraced it. Now, there are a lot of avenues that any administration can use to restrict imports, and all presidential administrations do this to some extent. And the Trump administration has made use of the usual avenues: anti-dumping duties, countervailing duties, safeguards, all these trade policy things that people here probably have no idea what I'm talking about. But what the Trump administration saw in Section 232 is kind of a blank check. If they could invoke national security, if they could make some argument that imports were undermining national security, then they just had wide discretion to impose tariffs or quotas in response. Now, most observers, including the Department of Defense, did not take the arguments for trade restrictions too seriously. So the idea that imports of Canadian steel are somehow undermining our national security because we can't trust the Canadians to provide the steel when we need it, people looked at it with a lot of skepticism. And when they extended the argument to automobiles, and auto parts, you think, really, the Toyota Camry, come on, it's people are very skeptical that there's much basis here. But nevertheless, the Trump administration has made use of this, and they've pushed the boundaries of this in ways that have been surprising even for the Trump administration. So one particularly outrageous action, it seems to me, is that the way these investigations work is that the Commerce Department investigates and then writes a report the president can act or not act. And so in the case of the investigation of automobile imports, the Commerce Department did a report, but it hasn't released it. And the report says, yes, there's a threat to national security and the president can impose tariffs, but he hasn't done so yet. Trump has sort of used that to threaten and negotiate with Europeans. But so Congress has said, well, okay, we'd at least like to see this report. Please show it to us. And the administration resisted even showing the report. And so Congress, in a separate piece of legislation, I think it related to appropriations, said, okay, in order to get this money, you have to show us the report. And the administration's response in a Justice Department memo is, no, we're not going to. Executive privilege, this would harm our diplomatic efforts to negotiate this national security issue. So they've really pushed the boundaries here. In terms of clawing back power, there has been a lot of talk about this. I guess my instinct here is that there's sort of informally, Congress is constraining what the Trump administration does. It looks to some extent like the Trump administration is just doing whatever it wants, but I think that they have acted within certain boundaries, not the boundaries I'd like, but certain boundaries. So they did impose tariffs on steel and aluminum imports, but they haven't so far on automobiles. And I think that's because the response they got behind the scenes was, if you do this, if you go ahead with tariffs on automobile imports, we are going to step in and amend this legislation and claw back some of those powers. So I think that there are informally some limits being set here, and the Trump administration is certainly pushing. The more it pushes and grabs power for itself, the more it stirs up certain members of Congress to try to push back. But, as the other panelists talked about, I mean, in this sort of partisan, setting, the situation that we're in, it's just really difficult. It would take something extreme to get Congress to actually act.
Okay, you kind of brought up this clawback conversation. So, is there even a practical possibility?
So just a couple quick thoughts. In the context of specific disputes that are happening, so under this Trade Expansion Act of 1962, and I should say I'm not a trade policy expert like Simon, but Congress can, the separation of powers are not just, Congress over here and the president, right here. The executive branch is massive. The president sits atop it, and everything underneath the president is basically designed by Congress, right? So Congress can make all kinds of sort of internal institutional design choices about how decision-making happens inside the executive branch that can at least either put a thumb on the scale substantively or create certain kinds of decisional process requirements that it prefers, right, rather than the ones that, say, are currently in place. And so the Tariff Act is an example. So this Commerce Secretary has to write this report, right, that Simon was talking about, finding that some national security need. But I think under the statute, the Secretary of Defense also needs to be consulted. And in this case, as to some of these tariffs, the Secretary of Defense, I think, refused to basically co-sign this national security justification. The Commerce Secretary made the recommendation anyway, and the President adopted it, I guess, at least in part. But you can imagine Congress deciding to give the Secretary of Defense some additional authority, or the only kind of, not to bind the President, but to provide the only recommendation that it is kind of a condition precedent to the exercise of whatever trade authority is at issue. And so I'm going to call it another law review article, which is by Rebecca Ingber, who really focuses on this as a kind of sort of underappreciated congressional power, which is to structure the sort of internal decisional processes inside the executive branch. So will that allow it to win any particular substantive policy battle with the executive branch? No, but it can change the sort of decision-making flow inside the executive branch in ways that more reflect Congress's substantive preferences than, say, the current configuration does.
So, Donald, let me ask you a question from an oversight perspective. Yesterday the Senate voted to acquit the president on the 2 articles of impeachment passed by the House. And so these proceedings were interesting for a number of reasons, in that you had the White House refusing to, in the words of the White House counsel, participate in the impeachment proceedings in any way. And, Kate already mentioned what that included. So we know that pundits and scholars are going to be debating this for years, public policy types, lawyers, you name it. So did the House and the Senate have any congressional tools it could use to wrestle information from the administration? Or was the White House letter, the end of the argument?
Well, I'll start with the House because I think the question has really been focused on whether the House should have used more tools at its disposal to, for instance, compel John Bolton to testify, things like that. Obviously, the Senate abdicated that responsibility. And so I agree with Kate that, yes, Congress has more tools, inherent contempt that can go into the courts. I think one question that I was left with is, to what end? The White House made pretty clear that it was uninterested in cooperating with the inquiry. They had worked pretty hard in the House to get witnesses that from the government that were willing to defy the president's order not to cooperate, and were successful in doing that. And so, I think the question the question is interesting in the abstract, but I think it's also informed by the urgency of the conduct underlying the inquiry, right? Here you have a president who exposed to everyone that he was willing to pressure Ukraine to investigate, or at least announce investigations of a political rival, then went on TV and said that China should investigate his political rival, then said that he was okay getting foreign assistance from a foreign power in support of his election effort. I think that creates a certain level of urgency that the courts have been unwilling to adopt in any kind of dispute between the executive branch and Congress. Usually they just defer and say, go negotiate and accommodate, which is fine when you're talking about why taxpayer dollars are being used to support some program that's not working. That doesn't really work so well when you're talking about national security concerns of the utmost importance that could potentially undermine an upcoming election. I think that one policy proposal that has been going around, and I think one that you'll possibly hear from crew about, is this idea that there needs to be some sort of rocket docket for these kinds of disputes between the executive branch and the legislative branch, to force the courts to opine on these issues before an executive branch can run out the clock, right? As a legal matter, the Congress has all of the advantage, right? Like, the case law is overwhelmingly in favor of Congress. As a practical matter, the executive branch has a substantial amount of leverage, particularly if you're in an election year and you can, sort of hold the ball until the courts either decline to do anything or until there's an election and nobody cares anymore. And so I think there has to be, so I think if you're House leadership, there's a pretty compelling argument that, given the urgency of the underlying conduct and the court's demonstrated reticence to engaging in these issues, and the administration's ability to delay, that moving forward with the best case that they had and putting pressure on the Senate to call additional witnesses, as has happened in every other impeachment trial that has gone to completion except for this one, was a smart strategy. And, I think ultimately the result doesn't reflect on the process. I think it reflects on the senators who decided not to call witnesses and who decided to ignore the evidence that was presented to them.
Since your organization, Crew, has used litigation as a tool to gain access to information related to ethics and transparency, do you think it's been a successful strategy to help Congress conduct its oversight responsibilities? And what are the limits of the litigation on protecting Article 1?
Yes, our litigation is crushing it. But I will say, look, we are not an organization that is looking to help Congress do oversight. We are an organization that is about accountability. Sometimes that means that we file lawsuits to help bring about accountability consistent with what Congress can do and is doing. Sometimes we are shaming Congress for not performing oversight. But either way, we are going to push for accountability. I think our litigation has been successful in some cases demonstrating that oversight can be done. I'd point to the emolument suit. We were the first organization to file suit in federal court on January 23rd, 2017. So President Trump's first day in office, or in the Oval Office, to seek remedy for his violations of the foreign and domestic emoluments clauses. Then we joined as co-counsel when DC and Maryland sued the president in federal court on behalf of their citizens. I should note that the lead sort of litigators on those cases are two of my classmates from Georgetown Law, so shout out to them. And then Congress filed its lawsuit. And I think all three cases are important, but I think it demonstrates that there is a role for good government groups like Crew and like others who were really, sort of on this at the beginning when, for the 2 years that Congress abdicated its responsibility to perform any sort of oversight. And I would note, even during the impeachment process, we've seen how organizations like American Oversight, the Center for Public Integrity, have really pushed for the exposure of documents that have been at the forefront of this inquiry and have highlighted just how damaging the obstructive conduct of this administration has been. One other Crew plug, because when the president announced that he was going to award the contract for the G7, hosting the G7 at his resort, there was a lot of outcry. We filed several complaints pointing out the egregious conflict of interest there was, and then the president recanted. But we kept pushing. And one of the things that we got through the FOIA process was a single document from the Department of Homeland Security and Secret Service, which eviscerated the president's claim that the Secret Service had been clamoring for the G7 to be hosted at his resort because it was so great for security. And what they said was, we have been through this process for weeks. And at the 11th hour, somebody on high said, oh, you should consider Doral as an option. We have concerns about it with respect to security. And that was a single email from that we managed to wrestle out of the agency. But at a time where the administration is not cooperating with oversight, I think litigation, particularly FOIA litigation, has proven valuable both for the sort of run-of-the-mill oversight, but also in the impeachment inquiry. And, I think the groups that have done that, Crew and other good government groups out there, are going to continue to do so.
Okay, as you've been out talking, and one thing that you lecture on, when you see that the president, Trump, is the second one to face impeachment for contempt of Congress, what do you think the Senate's decision to acquit the president on the obstruction of Congress charge, particularly on the facts that have been presented, say about whether the Constitution's views such conduct as criminal or impeachable moving forward?
So to return to something I said at the outset, right? It's in oversight in general, it's really, there's not tons of case law out there. In impeachment, that's really true, right? We don't have judicial decisions. In fact, we have courts telling us this is really something for the political branches. So, right, so the question, what is the law or the common law or the congressional law of impeachment, right? It really is a question of reading the record of each of the, the very limited number of impeachment episodes, obviously the very limited number of presidential impeachment episodes. So I think it's an important question, like what does the acquittal mean on obstruction of justice? I will say, obstruction of Congress, rather. So you mentioned this was the second obstruction of Congress charge, and so Nixon was charged with obstruction of Congress. The House Judiciary Committee approved 3 articles against him. Obviously, he resigned before there was a full House vote. But I actually do think it's interesting as a matter of history that was a much closer vote than the other 2 articles that the Judiciary Committee voted out. So the 2 substantive articles, obstruction of the Watergate investigation and abuse of power, were approved 2711 and 2810. The obstruction of Congress charge was like, failure, it wasn't called that, but it was failure to comply with subpoenas, et cetera, was approved 2117. So that was actually a much closer vote. So there's an interesting suggestion there. And then in the fact that it was the acquittal was, not dramatically different here, but that the one crossover senator, obviously Mitt Romney, who voted to convict on abuse of power, voted to acquit on obstruction of Congress. So, how much those mean in terms of formal precedent is obviously subject to dispute and debate. But there is a suggestion here that Congress is a little skeptical of the impeachability of defiance of Congress. And I don't think that means that it can never be the subject of an appropriate and kind of well-grounded impeachment charge. But I do think that it does suggest to me that these couple of limited data points reveal that even Congresses that, say, in the Nixon era were quite receptive to approving substantive charges of other sorts against a president are going to be slightly more skeptical of grounding impeachment on failure to respond to subpoenas, et cetera. Now, I don't disagree with Donald's assessment that it was a tactically quite defensible position to have decided to just move to drafting an article, but it's something to kind of reckon with for future Congresses that are thinking about how strong an article that looks like this might be. I think those 2 episodes do counsel a bit of hesitation around sort of predicating impeachment, at least, fully or in large part on this kind of obstruction of Congress theory.
So since some of you've worked on Capitol Hill, and Donald, I'll ask you this quick question. Can Congress really arrest someone who doesn't comply with a subpoena?
Oh, yeah. I mean...
Should they?
Well, yeah, I mean, like that, yeah, that's the question, right? I mean, and I think that's been revealed with a lot of these oversight issues, right? I mean, Congress, in theory, could force a shutdown and get documents that it has subpoenaed. But why would they ever do that, right? Because, there are people hurt by government shutdowns, and, they want the government to run. So, you can imagine a scenario where a cabinet secretary shows up for a briefing, and all of a sudden Capitol Police and the Sergeant at Arms are waiting there to arrest them. And there's a standoff between Capitol Police and some cabinet secretary security detail. That's an unmitigated disaster. Right? Just because Congress has certain authority doesn't mean that they can or should exercise it. And the way our electoral system is set up is that, there's likely greater likelihood and swifter political blowback on the House and the Senate than on, than on a president. And so I think you certainly caution against it, but I agree with Kate. I think the proposal from Good Government Now about how to utilize fines is worth exploring. I think you ultimately end up in the same sort of problem, which is if Congress levies a fine, how do you ultimately enforce it? But I think Congress should definitely explore more tools to get accountability from cabinet secretaries and from appointees who, quite frankly, don't have the same ability to duck them as a president does.
Simon, Zachary, I saw you smiling. Did you want to get in on that question?
Oh, the arrest question?
Yes.
I think I agree that it is a power Congress has, but what that would trigger is, I don't know. But it does actually kind of highlight another kind of broader point, maybe worth mentioning, is that we're used to separation of powers working relatively smoothly compared to the way they've operated historically at some periods. Things could get a lot more conflictual. A lot of these powers are there with a kind of idea that there's really going to be kind of bare knuckle fights, and I think we tend to recoil from that, but the kind of partisanship is probably pushing us more in that direction where things are just going to could get ugly. You could see presidents not following court decisions and things like that. I just think the political incentives might be pushing us there, and sort of, that's very disconcerting, but, at certain historical points in the past, things have worked more like that. And so it might be, maybe that's some reassurance that won't be the end of the republic.
Let's also look a little forward. Simon, you spend a lot of your time on trade policy, and you have worked very effectively in so many different venues. Recently, the senior vice president over at the U.S. Chamber of Commerce, John Murphy, who I know you know, described the U.S., Mexico, Canada as an agreement that will instill certainty about the future for much of the industry, from manufacturing to agriculture and services. Because as you could imagine, we move from impeachment, we're going to be talking now about presidential politics, and everybody's going to be talking about trade. They're going to be talking about what's going to happen. What do you see as an expert? Do you agree with what Murphy said, or what are your views on?
Well, I'm always happy to talk about trade policy all day, but this is a constitutional law gathering, so I'm going to also say something brief about the certainty, but then I'll turn it into a separation of powers issue. So on the issue of certainty, look, under NAFTA, we had certainty. Everybody was certain, but then Trump came along and he kept threatening to withdraw from NAFTA. Now, there was an interesting question of whether he had the power to withdraw, so there are people like Joel Trachtman at the Fletcher School who looked into this more carefully, and I'm just relying mostly on him and other people who did that research. And I think it kind of depends on which agreement you're talking about. The language varies. Regardless, Trump didn't care about any of that. He just wanted sort of the political, threat of I might withdraw from this. But anyway, now we have this USMCA. Presumably, Trump won't threaten to withdraw from his own agreement, although you never know. So we're almost back to where we started in terms of the level of certainty. there was an independent agency called the International Trade Commission. So in fairness to those who are talking about certainty, the International Trade Commission says, hey, this USMCA brings certainty because we now have all these digital trade governance provisions are all set and we can all rely on them, and that's going to add $68 billion to GDP. I'm skeptical. Most economists are skeptical that that's actually true, but nevertheless, they said it. So if somebody wants to say this will bring certainty, okay, I see they have something there. Now, in terms of the separation of powers issue, one of the really novel and interesting and to me very annoying things they did with the USMCA is they put a term limit on it. So it's supposed to expire, it'll terminate after 16 years, unless in 6 years all three parties agree to extend it. So the agreement just talks about, the parties extending it, and so I don't know how Canada and Mexico work in this regard, but in the United States there's a question of, well, who decides whether to extend it? I mean, you're talking about the president, you're talking about Congress. The president negotiates the agreement with authorization by Congress under Trade Promotion Authority, then Congress has to approve it. So shouldn't Congress have a role in this decision to extend it? And as this was going along, I argued that as much as I could to everybody I could think of to argue it to, members of Congress, you need to take notice of this and you need to assert some role here. Other than Senator Toomey from Pennsylvania, nobody seemed to care that much, and they let it go. And so the way it's been structured is basically that decision, the United States decision whether to extend, is going to be a decision of the president with subject to consultation with Congress. But it's a pretty loose consultation. What I was arguing for is the decision will be to extend unless Congress and the president both say no. I lost that argument. And in 6 years, we'll find out how this all works. This is new, uncertain, add some uncertainty. And, somehow Congress and the president are going to have a conversation about this, and then the president will make a decision. It's 6 years from now, so presumably, given, it's hard to imagine some circumstance where, unless they amend the Constitution, it won't be President Trump. It'll be some president who makes that decision, and then we'll learn how much certainty we have really achieved.
So on that point also, now all of our multilateral institutions they're front and center in all of our conversations. The WTO, we saw him recently, the president at an international convening, have an agreement or have a conversation about how he wants to further the actions of the WTO and America's role in that. How do you see, is there a role in there for Congress in these conversations? And what is that?
It's a great question. I mean, there should be, and there sort of is, but members of Congress, I think, are trying to sort that out right now. And there's a congresswoman from Florida, Stephanie Murphy, who just had a conference earlier this week, trying to figure out what can we actually do here. The President Trump, the Trump administration are going off into the WTO and all these different trade agreements, threatening withdrawal, demanding changes in ways that Congress often has concerns about, although not always. Sometimes Congress agrees, and so how can Congress act? But I think this goes back to what we were talking about earlier. I mean, in this partisan setting we're in, how is Congress supposed to? Congress isn't just this one entity. It's a bunch of individuals in two different parties and two houses of Congress. How are they supposed to agree and act and really really make their voice known? Because they don't act in one voice. So I think we're feeling our way through it. I think we got to the point maybe a year ago. I don't know. At some point at some point in the past, we got to this point where we said, we just need to get to the next election and see whether this is going to continue on. Because if it is, we need to deal with it. But if it doesn't, if we have a new president, maybe things will go back to normal. So I think everybody at this point is just, checking real clear politics, poll averages, and trying to figure out where we are, see if this is a long-term problem we're going to have to deal with, or it's just, back to normal and the problem is in a sense solved.
Let me also, before I turn it over to the audience, get some of their great questions, I'm sure, is that let's talk about social media for just a quick second. The president has the bully pulpit, but we've seen now that social media is just a part of our daily lives all day, every day, 24/7. But you have members of Congress who have Twitter handles, and many, are on Facebook and Instagram accounts. You have Bernie Sanders, the senator, he's followed by 10+ million. You have Alexandria Cortez, she has 6 million, but the president has 72 million. So how does this new, infiltration of social media into the politics play what role is it playing to widen the gulf between, say, the presidential powers and the congressional powers? And is there anything that Congress can do to regain, that advantage? So I started at the end with Kate. Kate, when I start with you. Yeah, yes, absolutely. Then I'll go to Zach and come down.
So I could talk about this topic all day, so I will try to be brief. So I am totally persuaded by the account of the political scientist Jeffrey Toulis, who has this great book called The Rhetorical Presidency, in which he argues that at the founding, the vision of the presidency was one in which popular address was basically off limits, that the founders were sort of so animated by their kind of fear of demagoguery that they created this institution of the presidency, and they normalized a bunch of kind of expectations around presidential behavior that really included no direct appeals to the public. Presidential rhetoric was supposed to be in writing, you address it to Congress, and that was basically kind of, as a matter of presidential kind of political culture, the norm for basically the whole 19th century, with the exception of Andrew Johnson, who was a demagogue and was impeached in part because he was a demagogue. But that really it's not until the administrations of Teddy Roosevelt and Woodrow Wilson that this kind of public-facing rhetorical president really kind of becomes the norm and the expectation. Obviously, today, kind of rhetoric is a very core feature of presidential governance. And that's true long before the kind of the Twitter presidency, right? So FDR's fireside chats are an important moment of public presidential address. In 1930, something like 40% of American households have radios. By 1940, it's 80%. So that's actually much broader penetration than the 70 million Twitter followers that you mentioned. Of course, the style of presidential address is quite different, right? Sort of presidents have always used, or since the kind of full flowering of the rhetorical presidency, presidents have always used the bully pulpit to persuade, but to kind of to attack and to belittle and to mock, and those are things that presidents have not typically done, at least not with the frequency that President Trump does. But on the 70 million figure, there's actually, the New York Times had this great kind of feature in November, I think, called the Twitter Presidency, and they did all this analysis of the president's Twitter feed, and there's like amazingly interesting findings. Of the 11,000 tweets that he had tweeted since between January 2017 and November of 2019, over half, like 6,000 of them, were attacks of some sort. Just charting the frequency of his use of Twitter. But one really interesting figure in there was that they did this analysis and they concluded that only about a fifth of the president's 70 million followers are voting age Americans. So that's actually a much smaller number than 70, obviously. So we're talking about 15 or so, 14, 15 million Americans, voting age Americans. So there's a lot of bots and a lot of non-voting age folks, kids, and a lot of non-Americans following the president. So the number is actually quite inflated. So we think about it in historical context, it's a powerful, powerful platform, but it's not so out of step. And in fact, it's less dramatic in its reach from, the radio and FDR's presidency. And I think there is some, so that's an important sort of corrective, I think, to the suggestion that he has no genuine rivals for kind of eyeballs and attention. And of course, members of Congress don't have nationwide constituencies, so it's not so surprising that nobody would rival him in numbers of Twitter followers. But the kind of the advantage the president has as the only person in our political culture who is understood to both speak to and speak for the entirety of the polity, is simply a fact of kind of a presidentialist moment that we are in. So the kind of qualifications of the kind of Twitter narrative notwithstanding, obviously he has a massive rhetorical advantage. And I have some thoughts on how Congress might work to right that, but I feel like I should stop talking and let others jump in. Zach?
I hate social media. I think it's just degrades the political culture. It leads to bumper sticker arguments, sort of misperception of how popular ideas are in the outside, in the general public, and promotes bombast instead of self-restraint and modesty. So I don't like it, but to Kate's point, I do think it's probably part of it is we're living through the sort of shock to the system of a new communications technology arising. I think people had a lot of anxieties about radio and television when they first appeared, and probably eventually will kind of adapt and get used to what to pay attention to and what to tune out and things like that. And it's also an interesting question. I know people have tried to figure out, but sort of, social media appears to promote tribalism and polarization, but it's also possible that, social media is polarized because we're polarized already. I mean, it's not clear which way the causal direction runs. So, it seems like a negative development to me, but I think we'll probably find a way through it.
Simon, what's your thoughts about that?
This is my favorite question of the session because I have no particular expertise here. I'm just spouting off an opinion. I just want to, so adding to what Kate said, the number may be 72 million, maybe it's only 15 million voting age Americans, and to qualify it even further, how many of those are actually his supporters? I used to follow him to retweet snarky comments. How many are actually supporters? It's a number that's not as big as maybe we're worried about. I also think there's an opportunity here. If you look at AOC at 6.3 million so far, I mean, she's young. Like this can be a springboard. The members of Congress can use this, at least in their individual capacity, to make a name for themselves, move up in their career. For whatever it's worth, I attribute Trump's political power, despite the fact that he's actually kind of unpopular. He seems to have political power, and I attribute it, and I don't know, maybe we have some actual psychologists in the room. I'm not one, although both my parents are. But so again, this is just my opinion. He's got this bullying personality where he just asserts things with absolute confidence, and people just cower before him. I don't know why people have so much respect for that confidence, uninformed confidence, but they seem to. Maybe they will learn a lesson from all of this. Again, as I said earlier, we'll find out in November.
Yeah, well, I think it's an important thing to remember that this president is a celebrity and was a celebrity and had a pretty substantial Twitter following before he assumed the awesome powers of the office of the President of the United States. I don't know how his @RealDonaldJTrump Twitter follower account compares to the @POTUS account, for example. But I would venture to say that he is unique for a lot of reasons, not least of which because he was a celebrity before he was elected to office. And so I wouldn't necessarily say that I'm concerned about social media and the power of the presidency. I'm concerned about this president's use of social media as I am about lots of things that he does. But I think the power of celebrity goes both ways. And, I think there are some clear examples of that when you look at someone like Representative Ocasio-Cortez, who, despite being a backbench member of Congress, who sits literally at the bottom of the dais on my old committee, the Oversight Committee, with the power of her social media following, she can enact change just through asking questions that blow up on her social media account, just by directing questions from her social media account to to a company, to an entity, to an agency, right? She can wield oversight authority without any actual authority whatsoever. And I think that is a positive power if it is used appropriately. One of the things that I remember from doing oversight was just how much weight a letter on congressional letterhead can have in the real world. I sent a letter when I worked for Senator McCaskill to a company about the surprise bills that people were getting when they went to the ER. And a couple of days later, I was getting calls from reporters, getting calls from investors because the company's stock price had taken a hit from a 2-page letter that the boss signed and sent out. Now, look at what AOC can do with a tweet. She can literally reverse conduct. And, I think the president's social media power is significant. But I look at some of the folks that have gained a substantial social media following, not because they're celebrities, but because they're public servants who ask important questions, and they're on both sides of the aisle. And I see that as a bit of a game changer in how oversight is done, quite frankly, because you don't have to get the sign off of a committee chair. You don't have to get a subpoena. You don't have to even go in front of a microphone. You can pull out your phone, use your platform, and enact real change that affects real people and exact real consequences on whoever your like perceived wrongdoers are, at least in the oversight context. And I think that is an incredibly valuable power.
So very great perspectives from 4 great panelists. Let's just open this up now for questions. Who has the first question right here? Let's start right here. Who has a microphone for her? Yes. Can you tell us your name?
Oh, Sharon Stout. What about Facebook and their policy about allowing lying ads? I don't think any Democrat can take advantage of that opportunity because the mainstream media would call them out and they'd be pilloried. But Donald Trump can do it. And coupling that ability to lie, to micro-target, and to raise funds raises questions about election influence that I think really need to be examined. Comments?
Who you want to direct that to? Kate, you want to start? Donald, Kate? Exactly.
I'm actually not an expert on this. I mean, I would just say it seems to me as a policy matter obvious that Facebook should just do no political ads for the remainder of this cycle. It seems like a doable thing, and I think that they're not a government entity, and so there aren't exactly kind of First Amendment line drawing problems in the same way there would be if a government entity was trying to do it. But as a matter of quasi First Amendment issues, I think that a lot of constitutional scholars, I think myself included, get a little bit nervous about any regulatory actor, even a private one, trying to draw a line between truth and falsehood, and that's inherently a subjective exercise. And so I worry about their ability to meaningfully enforce some kind of prohibition on political lies. I don't think government could constitutionally do it, with maybe a couple of little exceptions. And the Supreme Court hasn't, has actually been sort of protective of certain kinds of lies. I mean, they haven't sort of said in a categorical way that political lies are kind of are protected, but some kinds of lies I think are. And there's just a concern, I think, among kind of constitutional lawyers and that that line drawing exercises are so difficult here, and that sort of a prohibition on these kinds of ads, a year out from presidential elections would be just a great policy call, and that's what I would love to see Facebook do. Short of that, it's hard for me to see what they can do, and maybe that's like kind of a defeatist takeaway, but that's, I think, where I am on the issue.
Well, I see you trying to get in on that.
Want to answer that?
No, I don't really. Yeah. But what about it?
It exempts them. It exempts the tech companies as platforms rather than publishers, and so they can't be sued for libel, slander. If they were allowed to be, then that might put some check on the lies.
Yeah, I mean, it's certainly an argument that is made. I don't really feel like I have a strong position on that.
Donald, I saw you wanted to try to.
Yeah, very quickly. I mean, I agree with Kate that I have discomfort about social media platforms policing these things, but I also or deciding truth and falsehood. But I think there are also things that are demonstrably false, and some of the social media companies have totally abdicated their responsibility. And I think there are some actual lines that are far clearer, and the companies have abdicated their responsibility. I'll give you one example from Crew's work. Last June, the Office of Special Counsel found that Kellyanne Conway had violated the hat check so many times that she became the first, that OSC, for the first time ever, recommended to the president that a White House employee be fired for violating the hat check. A lot of those violations came on Twitter, and we filed a report in October citing that Ms. Conway had violated the hat check over 50 times using Twitter, right? That is a violation of Twitter's terms of use policy. She's using the platform to break the law and to do so in a way that by statute is aimed at influencing an election, right? That should be an easy argument, an easy case to make. And so far, Twitter has done nothing to curb that kind of conduct. And so, I think there's definitely more ways to have social media companies exercise some kind of authority and accountability for when bad actors are using their platform to break the law. I think drawing lines between truth and falsehood gives me some discomfort, but I think Kate's proposal is a good one.
I think we have time for one more question, or we can group another question together. Is there another one burning out here? I know we have her. Is there any other burning question? Because we can group them together.
Well, thank you. My question, Professor Tia Johnson, I'm here at Georgetown. I teach a course on congressional oversight. And so today's been great. My question goes to Donald, but anybody could answer it. I want to revisit an issue you brought up you stated that there were serious concerns about what OLC has done with regards to the president's ability for oversight. And I can't remember which federal judge it was, Amy Berman Jackson, Katanya Brown Jackson, or Chief Judge Howe, who in one of the court opinions said, the OLC opinions are not binding on the courts. So with that, I mean, is that a line of effort that maybe should be pursued either by Congress or by one of your organizations to kind of unmask some of these OLC opinions and hopefully have the court overrule them?
Certainly, we have gone to the mattresses to try and get some transparency with respect to OLC decisions. And I think it is accurate to say that OLC opinions are not binding on courts, but they are binding on the executive branch. And so as a practical matter, the executive branch, and this comes down from the top and often from the Department of Justice, who gets consulted about oversight matters, that OLC opinions are the law for the executive branch, and that executive branch officials should not take steps that violate them. Obviously, as I said, Ambassador Sondland and Ambassador Yovanovitch made a different choice, and we're sort of seeing what the fallout has been for them. But I think and that is the thing that gives me a lot of concern. As you said, I don't have. I'm not afraid that the courts aren't going to stand up for Congress's authority to conduct oversight. I'm afraid that the decisions the opinions that OLC has made give this president and the next one a lot more cover to obstruct Congress, and Congress can't litigate everything, right? The House Counsel's office isn't that big. Committee staffs aren't that big. Frankly, committee chairmen don't have the stomach for going to the mattresses on all of their subpoenas. And so as a practical matter, it is a not insignificant concern. And I think it'll depend on whether individual committee chairmen and chairwomen have are going to assert their authority, and maybe whether the House and the Senate are going to plus up their litigation chops to put more pressure on the courts and to shame some of these agencies and shame presidents if necessary to force more compliance.
I think they said we have time for one more question.
I think it kind of ties into your question. Donald and Kate talked about some of the accountability measures that Congress can take. You talked about litigation. You talked about some statutory provisions within the executive branch, but are there, it seems like that takes time. So what are some more immediate kind of actions, accountability actions that Congress can take, or if there are any, I don't know.
Who wants to take a stab at that?
I'm sure we'll have thoughts, but just a couple of things. I mean, I think that, Congress obviously is bicameral, and I think that there's actually an important difference between the Senate and the House in some ways. Like the Senate actually has kind of more unilateral authorities, more responsive ones, right, to Donald's example about Merrick Garland. So confirming judges and executive branch officials and ratifying treaties, which, they don't do that much, but like in theory they do. And so the House, has to originate budget bills, but doesn't have that much else that the House alone does. In some ways, like impeaching president or impeaching federal officers is like one thing that the House can do on its own by a simple majority vote, which is why I think that, despite the ridiculousness of a lot of the presentation, Ken Starr's suggestion that we may be on the precipice of the age of impeachment, or maybe we're already living in the age of impeachment. There is a point there if the president and the House, right, come from different parties, House majority that is. But so from the perspective of the Senate, holding up confirmations of officials, right? Like that's a very powerful, I think, sort of power that can induce lots of compliance. if the Senate sort of wants to do that. More long-term, I think that empowering, protecting whistleblowers and empowering inspectors general, so IGs inside federal agencies, are really important internal watchdogs, I think, who serve a very important function in the absence of an independent counsel statute to investigate executive branch wrongdoing. So agencies already have IGs, so protecting IGs, and that is, in theory at least, a quite bipartisan policy commitment to protect IGs, right? Chuck Grassley has always been sort of the most supportive member of the Senate of whistleblowers and inspectors general both. And so that, I think, empowering these kind of watchdogs and checks inside executive branch agencies, both through substantive statutory change and then just through, whether we're talking about resources and staffing of those offices and those kinds of things. But that is something I think quite important. And now, if we're talking about statutes, obviously that's a two-house affair that the president could decide to try to obstruct. But generally empowering and supporting the work of those internal executive branch players, I think, is quite important and something Congress can do.
Donald?
Yeah, I mean, one, to echo Kate, I think more collaboration, both between committees and between chambers, is important, right? Like, there's two things that the executive branch still has to come to. They have to come get their money, and they have to have their nominees get confirmed, right? And so those are people that have to sit in the hot seat and answer questions. A lot of times during these appropriations hearings, people are asking about parochial issues, which, I mean, given gerrymandering, quite frankly, don't matter that much, right? You can get those questions answered without the lights on. But I think if there was more coordination, for example, between the appropriators and the oversight folks, it might make those hearings a lot more uncomfortable, and agency heads can't really duck them because they have to defend their budget requests. I think in the Senate, you get these nominees in front of your committee and you lock them down about complying with Congress, or you leverage a nominee that a cabinet agency wants to get information that you've requested out of there. One of the first investigations I worked on in the House for Representative Cummings was the Operation Fast and Furious investigation. And it's a classic example of how Senator Grassley, who at the time was in the minority, leveraged his colleague Darrell Issa in the majority and got a whole bunch of subpoenas and basically launched an investigation that ended up with the Attorney General of the United States becoming the first cabinet secretary to be held in contempt of Congress because he knew how the process worked. He worked well and played well with his colleague. I think he chose oversight over his judiciary counterpart strategically. And I think that is an example of how Congress can assert its authority if they play well with each other and play well strategically. I think the other thing I would say is that not every president has the both the sort of gall and the protection that President Trump has, right? I think everyone has sort of accepted that he's kind of Teflon with a certain segment of the population. But what we have seen is that cabinet secretaries, nobody knows who they are, nobody cares who many of them are, and that they can't get away with the same things that the president does. And so, when it has suited his purposes, some of his cabinet secretaries have been underwater for obstructing Congress, for ethical violations, and he has jettisoned them quickly because they have become liabilities to him. And I think Congress can assert its authority and against cabinet secretaries and lower level agency officials and put pressure on them to get moved out of office, especially with a future president that has less of a tolerance for that kind of misconduct.
Zachary, I think you want to jump in.
Yeah, just a brief thought. I agree with all that, but just to highlight, I think another really important power that Kate mentioned earlier that Congress has, along with appropriations, I think it is very important. This environment is the power to vest authorities in officers other than the president. There are, long-standing constitutional debates about the extent of that power, but I think it's a clear power that Congress has that's supported by practice and history and so forth. And I think it's turned out to be a really important constraint on this president, among others. I think the clearest example is actually the special counsel investigation. The power to fire the special counsel did not belong to the president personally. It belonged to the attorney general. And of course, the the president can normally get his way by telling a cabinet secretary what to do, firing them if they don't do it. But I think that illustrates how just having that distance, having the president have to take that step sometimes to get their way can constrain what government does. It also can kind of make government agencies more responsive to Congress, to appropriators, and to kind of broader professional and political networks. So I think it's a kind of underappreciated constraint on presidents that sort of as a feature of the constitutional design, it's often not the president. The president is in some sense the boss, but it's often someone else who has to actually make the decision. I think that's a power Congress is aware of, but could use even more significantly if it chose.
Simon, did you have any closing comments? You know, having a panel of scholars and public policy experts has really been very fascinating. And first, we want to just say to Zachary, congratulations on your full professorship at Hastings. And I tell you, keep watching for his articles in the Take Care blog. As a former DOJ lawyer, I know you'll have a lot to say about this. We want to thank Simon Lester from Cato. Let's give him a round of applause. I'm telling you, you're going to hear a lot more from Simon. If you haven't been reading his material, you should be. He has been at the Secretariat with the appellant body of the WTO. And so all these issues around trade is going to be at the highlight in the forefront going forward. And so all of the issues I think that we're talking about a resurgent Congress is going to be playing out at will for in the coming future months. And then Kate, we just really appreciate you being here. You as a constitutional scholar at Cardozo and having served one of the Supreme Court justices, John Paul Stevens, we are just really appreciative of the work that you've done with him and your fellow other judges that you've served, and definitely in the Obama administration. Let's give Kate a round of applause. And then Donald, you know, you're the first one that's been talking about going to the mattresses. So for those of you who do not know, you can come up and ask them afterwards. But we really appreciate the litigation work that you and AC, you've been working with so many partners around Washington, and having had that experience in the House and the Senate from oversight, whether it's been on government reform or homeland security or the ethics committee, it really, all of the comments I think that all of you have shown here today came through. Let's give him a round of applause. And as we close out this panel, we want to just, this panel wants to thank Nick for introducing us, and Deborah and the ACS for letting us be here today. We really understand now, I think fully, that these are the issues that's going to be playing out going forward. We're going to be hearing them night after night on television. So we've talked about a lot of history, but I think we also have talked about a lot of reality. And as we move forward, I think you all have given some good tools or methods that Congress can use if it wants to reassert itself as we go forward, not only in an election year, but as we come for a new Congress in the 117th. And with that, just want to thank the audience for being with us today.
Hi, everybody. I promise we'll be very brief. My name is Brett Graham, and along with Shelby Smith, we are the co-presidents of the ACS Georgetown chapter. Just wanted to say thank you to everybody for being here today. Thank you to the Georgetown facilities for setting up this beautiful room for us. Thank you to everybody at ACS Nationals who helped make this such an amazing and informative day. Thank you to all of our panelists and our speakers and our moderators. And Shelby's just going to close us out with a few reminders.
I just wanted to echo Brett's remarks and remind all of you, especially you attorneys in the room, that our chapter at Georgetown is always looking for attorneys around the area and elsewhere to get involved with event programming. We love to hear from professionals in all diverse positions and from all different areas of the legal profession. So if you're interested in that, please find Brett or I after this, and let us know, and we would love to set something up with you. And with that, Deb, thank you and have a great day.
Thank you.